So once again, to resume here, when we were talking about assignment, what is assignment again? It's if I am subleasing, I could assign my obligations of the lease to another tenant. So now that other tenant has to rent and pay the rent. But if they fail to, then I am never relieved of my obligation to the landlord because I am the primary renter to the landlord. So the landlord's renting to me and I'm renting to someone else if the landlord allows it. If they don't pay the rent, I'm still obligated to pay the rent. So when you assign a contract, your rights or obligations in a contract to someone else, you are never relieved of your obligations. You still always hold primary responsibility for those obligations. Now, is it possible that you can assign your obligations to a contract to someone else and be relieved of those obligations, that they're taken over by someone else? Yes, it's called novation. Novation is either substituting one contractual agreement with another or substituting a person named in a contract with another person. All right? And that's a formal way of assigning where you're also going to be relieved of your legal obligations to the contract. So go down to assignment and novation in the book, which there is no good definition here, by the way. But we'll highlight still where it says assignment and novation on the bottom of page 170. We're going to highlight novation or the substitution of a new contract for an existing agreement. And then the last line on the page we're going to highlight. In the case of novation, the old contract no longer has any force, meaning it has no legal force. It cannot be enforced, okay? So novation is basically replacing one contractual agreement with a new one, or keeping the contract that you have in place, but just changing the parties named in the contract. You're substituting one person named in the contract for another person. They refer to this often as novation of the parties, okay? You're not changing the contract, you're novating the parties. Novation is substitution. You're either substituting a contract with another or a person named in the contract with another. Whereas the original contract or the original person named in the contract has no legal further obligations. Everybody follow that?
Yeah.
We would not do this, attorneys would. Okay, but still we need to understand the terms. Novation, you'll usually see on exam. So understand what novation is. And understand that when you assign a contract, are you ever relieved of your obligations to it?
No, you're not.
No, you're not. Correct. All right. So, breach of contracts. I told you breach of contract is when somebody breaks the contractual terms. They violate the terms of the contract without having a good legal excuse to do so. So therefore, they could be held legally or financially liable to the other party. So if a seller defaults, we're going to go over if a seller defaults, what are the buyer's options? If the buyer defaults, what are the seller's options? So first, we're going to start with if the seller defaults, what can the buyer do? Okay, so this is that whole area of, actually they got it in a little bit of a different order here. Really? Discharge contracts. And then breach of contract. Let me see. Oh, okay. I missed that slide. It looks like we skipped over a slide here. All right, so discharge of a contract. Before we get into that, we're going to go over discharge of a contract. Now, there's nothing in this section to highlight. I just have a little bracket around it and says explain it to you, okay? So what are the different ways that a contract can be discharged? Well, partial performance. What does that mean? It means the parties have only partially performed their legal obligations of what they promised to do in the contract. So they didn't do everything that the contract required them to do. They've only partially performed. Okay? So if they did that, the contract can be discharged for that. They're basically in breach of contract in that situation. Substantial performance. Substantial performance means that the parties to the contract did everything they were supposed to do. They just didn't do them exactly the way the contract required them to do. So they have not substantially performed. They did what the contract required, but not exactly as the contract specified that they were to do it. So they've only substantially performed. Impossibility of performance. That's when the contractual terms cannot be carried out for various reasons legally. For example, they're not able to get a permit to use the property for their intended purpose, or they're unable to get a certificate of occupancy due to the condition of the property, or some other legal condition cannot be satisfied or met. Mutual agreement. Both parties just simply agree to cancel the contract. Contracts can be discharged that way. Or by operation of law, as in with the voiding of a contract as a result of fraud. How could that happen? I don't know. Maybe the husband and his girlfriend posing as the wife signed a contract. You know, I don't know. There could be a lot of reasons for it. A contract with a minor, expiration of a statute of limitations, contracts being altered without everybody agreeing to those altered terms. You need the consent from all parties in a transaction. You can't have one party to a transaction start changing the terms of the contract and everybody be obligated to it. The second that somebody changes a contract and the contract is voided basically unless everybody agreed to all those changes. Okay. One party can't unilaterally make changes to a contract without the other party agreeing to those changes. Now, breach of contract, once again, it's when one party violates the terms of the contract without having a good legal excuse to do so. So in this case right now, we're going to start off with, if the seller defaults, what can the buyer do? So the buyer can rescind. What does that mean? That means to cancel, to take back. So the buyer can rescind the contract to recover their deposit money, their earnest deposits. 2, the buyer can sue the seller, what we call a suit for specific performance. This basically sues a suit for specific performance is when one party sues another, forcing them to do what the contract required of them to do. It's forcing them to specifically perform, okay? So specific performance, that's exactly what it is. It's a suit forcing somebody to specifically perform as dictated in the contractual agreement in which they agreed to. So an example of this would be if the seller backs out of a legally binding contract that they're already in because they simply change their mind and they don't want to sell. So at the closing table, they say, you know what, I'm not signing, I'm not selling, I changed my mind, you know? Well, at that point, that late in the stage, the buyer can sue the seller and have a judge force that seller to turn over the property to the buyer. Because that late in the stage, you can't, that late stage in the game, you can't just, I don't want it. Well, actually, can they do that? Sure, they could do that. But then the buyer can sue them and have a judge force them to perform as they contractually agreed to. Instead of just suing them for money, they could force them to actually carry out the terms of the contract and basically hand over the property. Okay? Now, generally speaking, we're also going to go over if the buyer defaults, what can the seller do? Here's a general rule of thumb pertaining to specific performance. I say it's a general rule of thumb because is it going to happen in every case? No, because not all judges rule uniformly. Sometimes judges make wacky decisions. Generally speaking, in a suit for specific performance, you can force a seller to sell, but you cannot force a buyer to buy. unless they're a moron. I'll just leave it at that for now until we get to it. Let you stew upon that for a moment. And I'm going to back up that statement. Now, or 3, the buyer can sue for compensatory damages, compensation. Anytime you hear damages or compensatory, we're talking about money. They're looking for something to make up for their loss of time, loss of money, loss of whatever, for their damages, okay? So basically the seller would have to pay the buyer something, okay? So in the book, on page 171, under breach of contract, we're going to highlight the first sentence, almost the first sentence. It says, a breach of contract is a violation of the terms of the contract, conditions of the contract, without a legal excuse. And then we're going to either underline, just underline it and put stars or asterisks on both sides of it, just so that you can see this is a title. It says, if the seller defaults, the buyer has 3 alternatives. And then do the same thing to the title 3 things down, where it says, if the buyer defaults, the seller may pursue one of the 4 courses, and underline that and put stars on both sides of that so that you can see that that's a title. Okay. And then we're going to highlight number 2 in the first section, if the seller defaults, that says, a court suit known as an action for specific performance to force the seller to perform the contract, i.e. convey the property. You will need to add that terminology, specific performance. Specific performance, you need to add that terminology to your definition list. You'll need to know it. It will be on exams. What is a suit for specific performance? But they're not going to ask that straight out. They'll give you a scenario, and you're going to have to choose specific performance as being the answer, okay? So one way or another, you will get asked about specific performance, so you should understand what it actually means, okay? So it's a court action where one party sues another, forcing them to carry out the terms of the contract as agreed. All right. Now, what happens in the event that the buyer defaults? What can the seller do? If the buyer defaults, what can the seller do? Well,
they can sue them for time and money, like compensation.
Well, first of all, let's go over a term. Here's a term that we're going to go over in this. Actually, no, we'll hold off on the liquidated damages. Let's go down to, if the buyer defaults, what can the seller do? Actually, no, this will be in the first one here. Yes, they could sue. The seller can declare the contract forfeited if the contract stated that they can, and if it was agreed that they would be awarded compensation as liquidated damages. But okay, so here's another term to add to your definition list. What are liquidated damages? It's an agreement. It's the agreement of how much money is to serve as compensation in the event that one of the parties breaches the contract. Okay? But it's just an agreement on how much money is going to serve as compensation. Now, sure, they could also write in that agreement where the money's coming from. But to get the exam question right, don't focus on that. Focus on just the simple part what are liquidated damages? It's just an agreement on how much is going to serve as, how much money is going to serve as compensation in the event that one party does breach the contract. Okay? So if a buyer defaults, I'm sorry, the seller can sue them, basically forcing them to pay them. Well, they don't have to sue them, but well, they may have to. It depends if the seller, if the buyer fights them on it or not. But it was already in writing, and this would have been added into the contract. It's not automatically added in contracts like the book suggests. The book says the seller may declare the contract forfeited, and the right may be provided for in the contract. The key there is may. That doesn't mean that it's always in the contract, okay? The last version of the book, I think, in the 13th version of the book, it has a little more wording that it's usually in the contract or something along those lines. Now, may have provided for the contract, and according to the terms of the contract, the seller may be entitled to retain the earnest money, that's the deposit money that the buyer put down, and all payments received from the buyer as liquidated damages. Now, I say may, but that's only if it was agreed upon that the liquidated damages are coming from the buyer's deposit money. Look, this agreement for liquidated damages could exceed the amount that the buyer put down as well. So it's just an agreement on how much serves as compensation, and then they could also write, well, we're going to start by taking that money from the earnest money deposits that the buyer put down when purchasing the property. And then where does the additional money come from? Well, they probably have to sue them to get it, okay? But since we're already having possession of some of their money in the escrow account, then we could start there, basically, is what's being said. Okay? So what is liquidated damages?
An agreement of the amount of money that is going to be recovered.
Correct. It's an agreement on how much money is to serve as compensation in the event that one of the parties breaches a contract. And although it could specify where the money's coming from, it doesn't necessarily do that. So for exam purposes, you just need to know it's the agreement on how much money. Is liquidated damages the earnest money deposit?
Not
Repeat
necessarily.
the question.
I said, is liquidated damages the earnest money deposit?
Not necessarily.
Not necessarily. So the answer would be no, right? So if you see that as an exam answer option, and you will, do not select that as the answer option. It could be, but only if they specified that it was going to be. All right, so it's a little semantics game that they play right there just to make sure you understand truly what liquidated damages are. All right, this is why I'm spending this time explaining it to you instead of just reading it and then moving on. Okay, all right, so now let's move on that you understand that. Okay, so this is a good definition that I gave you right here to understand it. Now, so the buyer, if the buyer defaults, the seller can also rescind the contract as if it were never made. However, this would require them to return all the deposit money to the buyer. Okay. Now, the seller could also sue the buyer for specific performance. But wait a minute, didn't I tell you on this previous slide, specific performance is when one of the parties breaches the contract and they sue the other, forcing them to carry out the terms of the contract as agreed. Well, I told you that general rule of thumb is you could force a seller to sell, but you can't force a buyer to buy. And then I said, unless they're a moron. And here's what I mean by that. This would require them to sign over the deed to the buyer and then chase after them for the payment. what the seller would be required to do. So what do I mean by unless the buyer's a moron? Here, when does the transfer of ownership take place? Well, when the seller signs the deed, naming the buyer in it, and the buyer takes possession of the deed. But if you got the buyer at the closing table and they're like, you know what, changed my mind, I'm not buying. And the seller's like, yeah, okay. And they sign that deed and they hand it to the buyer and the buyer still takes it. What did you think? They were just giving you the property? Now that they rendered that deed to you, as it says here, now that they've rendered the deed to you, you took the ownership, you took possession of the ownership, you have to pay for it. So now the seller can chase after that buyer for it. If you didn't want the property, don't take ownership of it. But if they took ownership, now you got to pay for it. So what kind of a moron thinks that the owner was just going to give it to you? Right? So that's where I said, unless they're a moron. Okay? You don't want the property, then don't take the ownership. Right? Now, can people back out of the contract at closing? Decide they're not going to buy or decide that they're not going to sell? Can they just do that?
No.
Yes, they can.
If they both agree.
Doesn't matter if they both agree or not. Can you kill your neighbor? Sure you can.
No.
You'll probably go to jail though. Anytime that I'm asking you a question that says can or could, or anytime you guys ask me a question that begins with can or could, my answer is going to be yes, you can. But there's going to be consequences. Can I kill my neighbor? Sure you can. You'll probably go to jail. Right? Can a seller back out or a buyer back out at closing? Sure they can, but they'll probably get sued. There'll be consequences of some sort. Okay? But that's their decision to make, not mine. Look, can a seller cancel the contract after they're already in a legally binding contract with a buyer so that they can accept another offer, even though they're already in a legally binding contract to sell it to somebody?
Yes, I can.
Yes.
But they better consult with their attorney on this because there are going to be legal consequences. That buyer may sue them. So you gotta be aware. You gotta be aware that there are some possible legal consequences that may come out of that. If you cancel that, you are in breach of contract. Therefore, you can be held financially or legally liable to the buyer. Okay? And the seller can sue for compensatory damages, forcing the buyer to pay them. Because look, I had my property off the market this whole time and you were just screwing around. You had no intention to buy or follow through, or whether you did have an intention, but now you're backing out of it. You're under a contract, legally binding contract with me. You can't just back out and expect me to just let you walk away. I had my house off the market all this time. And since then, I could have had another buyer that was offering me even more money, but I was stuck to the contract to you. And now you're backing out of it. I'm going to sue you not only for the damages, but the loss. If I can't sell this property for more to make up that difference, I want you to pay the difference too. Okay? See, these are all possibilities of what can turn out in a lawsuit. Okay? So, highlight the term number 1, liquidated damages. There will be someplace else in the book here where that is written. Liquidated damages, where is that? There will be a definition, I think, at the end of this chapter as well, which I don't have the cross-reference written in here yet. On page 189. So let's put a little cross-reference to page 189. Under next to liquidated damages, just write page 189. And I'll do the same thing on this slideshow, which may disappear because I got to minimize it to make those changes. Liquidated damages, page 189. Screen.
I have a question.
Yes, yes.
The difference between liquidated damages and compensatory damages is that just liquidated damages are specified as to where the funds will be coming from versus compensatory is.
No, liquidated damages could specify where the funds are coming from.
Mhm.
Okay, so damages is compensation to one party, right? Liquidated damages is an agreement. You see here, I have it in quotes here. It's an agreement. So liquidated damages is an agreement. That's all it is. It's an agreement in advance about how much money is to serve as compensation in the event that one party does default.
Okay.
Now you could add to that and then say where the money's coming from in addition to that, but it doesn't necessarily have to. So therefore, liquidated damages is just an agreement on an agreement in advance about how much money is going to serve as compensation. Here, let me back out of this again and let me change that in the definition. So liquidated damages, I'm going to put an underline under that too, is an agreement in advance about how much money will serve as compensation if one of the parties, usually the buyer, defaults. There can be additional wording stipulating where that money would come from. All right. Damages, okay, damages are not necessarily coming from the earnest money deposit unless it was specifically stated in the agreement. Damages could exceed the earnest money deposit. Right? Yeah. Keep it at that. That looks good. How does that sound? Does that sound like a good wording? Or can you guys think of better wording that I could put in there for that? Or is that sounds good, right? See the modifications I made to liquidated damages here? I said, is an agreement in advance about how much money will serve as compensation if one of the parties, usually the buyer, defaults. There can be additional wording stipulating where that money will come from. Damages are not necessarily coming from the earnest money deposit unless it was specifically stated in the agreement. And damages can also exceed the earnest money deposit altogether, right? So, there we go. So, page. All right, so on page 189, the last paragraph on the page, bless you. The last paragraph on the page on 189 under contingencies, we're going to highlight liquidated damages are an amount of money agreed to in advance by the buyer and seller that serves as compensation if one of the parties does not live up to the contract. Just highlight that. But it goes on to say, if a sales contract specifies that the earnest money deposit serves as liquidated damages in case of default by the buyer, the seller is entitled to keep the deposit if the buyer refuses to perform for no good reason. The seller who does choose to keep the deposit as liquidated damages may not sue for further damages. Okay? Because you came up with an amount in advance that you would be okay with. Okay? So liquidated damages, that was on page 189, but it was also mentioned on 171. So 171 and that's there. Okay, so we went over a bunch of terminology here. Let's just do a little recap so far in this chapter. What are the 4 essential elements of a valid contract? Competent parties,
Offer acceptance,
offer and acceptance,
consideration,
consideration,
legality of
and legality of the terms of the contract, right? Or the purpose of the contract. And what are the 3 legal forms of consideration?
legal tender,
Legal tender, that would be money or a mortgage loan. What else?
Love and affection
Love and affection,
and
Exchange
exchange.
of value.
and an exchange of something of value. Correct.
Yeah.
Whether it's goods or services. Okay. And what law states that written contracts take precedence over verbal agreements?
Parallel evidence rule.
The parole evidence rule, the one that shows that you got evidence. Otherwise, they're not going to kick it out of court unless somebody got evidence, right? So parole evidence was a way to try to remember it. And what law says that all contracts for sale for real estate must be in writing? And if it's a lease that's longer than how long does it have to be in writing?
2 years.
3 years. If it's 2 or more years, it can be recorded. Okay. That's the additional thing I had you write down there at the bottom. All right. And so what law says that requires contracts to be in writing?
Statutes or frauds.
Statute of frauds. To prevent fraud, all contracts have to be in writing. Okay? And you're going to see this doesn't only deal with real estate contracts. It also deals with the deeds themselves have to be in writing. We're going to hear statute of frauds pertains to several things, and we're going to see throughout the book still. Statute of frauds is going to come up again and again, but it always has to deal with something having to be in writing. That's just the basic gist of it. So you know that, you'll get the question right. Statute of frauds has something to do with something being in writing. But pertaining to contracts, you need to know all contracts for real estate have to be in writing, and leases have to be in writing if they're longer than
3 years.
2 years.
3 years, and they can be recorded if they're longer than
2 years.
2 years.
all right, so that's that. Now, if a real estate agent's involved in the transaction, how long does the lease need to be in order for it to be in writing?
Right away.
Right.
They all need to be in writing, right? Unless the lease is a seasonal rental less than 180 days. That was chapter 2. All right. I believe it was chapter 2 anyway. Let's see. What page are we on? Oh. Contracts can be implied or express. What is express contract?
Everything
Party
must,
state that the term,
How do you express yourself?
Oral or
use.
written.
all the terms are
Oral or
written
written.
down.
Usually,
In words. Ba, 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 in words. I'm moving my mouth, right?
Words and terms.
Okay, in words, whether it's verbal or in writing, you express yourself in words. Okay. Now, what's another way that you could express yourself?
In writing.
Implied.
Your actions, your movement, your actions, right? So if it's not verbally, in writing, in words, or verbally, okay, that's in words, whether you're talking them or writing them, that is expressing. Now your actions, your movements, your actions can also express yourself. However, that leaves something to interpretation because you didn't lay down all the terms in writing. You only did it by actions. So if you just accept the check, the landlord just accepts the check from the tenant, their actions say that, or it can be interpreted that your actions say that you're okay with that tenant staying there as month-to-month tenant. But because you didn't say anything, it leaves some things to interpretation. Contracts can be bilateral or unilateral. What is a unilateral contract?
if one party has to,
One-sided agreement.
and the
One party has
One-sided agreement.
It's a one-sided agreement where one party has an option to act and the other party has to act, but only if the other exercises their option to act. In a bilateral contract, both parties are required to do something. What do we call a contract that can be disaffirmed by one of the parties?
What was the question again?
What do we call a contract that can be disaffirmed by one of the parties?
Unilateral.
Contract.
Voidable.
well,
Like a contract with a minor is voidable, but only by
Avoidable, yeah. Mhm.
a strict deadline that must be met in a contract.
Time of the essence.
Time
Time
is
of
of the
Time is
essence.
of the essence. Time is of the essence. Formally replacing one person in a contract with another, or replacing one contract for another, whereby the original has no further legal obligation.
Novation.
Novation.
Novation. Because if it was assignment, you still hold primary legal obligation, okay? So it is novation. And a lawsuit forcing one person to carry out the terms of the contract as agreed. A lawsuit forcing one person to carry out the terms of the contract as they agreed to in the contract. Specific performance.
Breach of contract.
And an agreement about the amount of money that's to serve as compensation in the event of default, liquidated damages.
Liquidated damage.
See, we already went over a lot of terms that you will see on exams. This chapter is rich in them. A lot of terms. All right. Now, statute of limitations. What are statute of limitations? It's a time limit in which one has a right to assert their legal rights. You go over the time limit, you lose the right to try to enforce your rights. Okay? So for certain things, when it comes to contracts, foreclosures, mortgages, in cases of fraud, there's a 6-year statute of limitations. But lawsuits to recover real property, it's 10 years. So go down and we're going to highlight the last, we're going to highlight the word statute of limitations on the bottom of page 171. And then and then highlight the last sentence that says, the 6-year period applies to contracts, foreclosures, mortgages, and cases of fraud, and lawsuits to recover real property have a 10-year statute of limitations. Let me ask you a question about record keeping. How long do brokers need to keep all records for?
6 years.
6 years.
6 years.
I wonder why.
So the statute of limitation, to suffice the statute of limitation.
Yep. Because if somebody decides they want to sue for the contracts, what have you, then we can prove it because we still got the proof. We got the original paperwork, right?
Yeah.
Now, lawsuits where somebody's trying to claim ownership and regain the ownership of the property, well, they got 10 years for that, but they're SOL if they don't have their old paperwork, their original paperwork, right? SOL.
Question.
It means shit out of luck. Okay.
I had a question.
Yeah.
Have you ever had any problems with your clients when like trying to sue you back for any reason?
Do you hear this? I'm knocking on wood. No, thank goodness I've never been sued by one of my clients. No. Or anybody.
Like it's not a common thing.
What, getting sued? It
Yeah,
happens,
like
but it's not like everybody's out there suing crazy over real estate issues. But there are
Okay.
plenty of lawsuits pertaining to it, so it's not an uncommon thing, I don't want to say.
okay.
This is why we need to carry E&O insurance, errors and omissions insurance, right? Stuff happens, we're only human, right? At least I am. I don't know you guys, maybe you're superhuman. So, contracts used in the real estate business. All right, so page 172, contracts. Basically, a lot of this rest of this chapter is going to be going over all the documents and all the disclosures and all the whole processes that we already explained throughout this book on how we get the listings, how we start working with buyers, the disclosures that we give them, all the way up to the point to where we put a contract in writing. And then we're going to start talking about the actual contract and what's required to be in the contract. And then that's pretty much the rest of this chapter. There's actually a contract here too, which I'll briefly go over, showing you how to put it together. All right.
All right.
So preparation of the documents is the first step. Licensees can only prepare contracts for what kind of properties? Residential 1 to 4 families and single residential lots, right? Now, we're not writing these contracts from blank. They're fill in the blanks, okay? And so these contracts are already prepared by attorneys and they're approved by the Real Estate Commission for us to use. We only fill in the blanks on these contracts. We're not writing them from scratch. We're not attorneys. But if your office is going to be using some kind of custom contracts, you got to make sure that they are approved by the Real Estate Commission to use, because and that they abide by the law. Remember, we've gone over a lot of stuff that are required to be in contracts, but I keep telling you, well, you don't got to worry about that. That's already built into our contract. You don't got to worry about that. That's already built into our contracts, because the standard contracts that were made by the Realtors Association make sure that we're obeying all the laws that are out there for the things that are required to be in contracts. And so we're going to kind of just like reiterate that stuff now as we get to the contract. But first, before we do that, we're going to highlight New Jersey allows brokers or their agents to complete residential leases and standard approved sales contracts on 1 to 4 families and single lots, residential lots. All right. Now, commercial properties, can we sell them? Yes, we can sell commercial and industrial properties. We just cannot prepare the contracts for sale or lease on those commercial properties. Okay. Now, New Jersey has a requirement, says we must indicate the business relationship with respect to the parties named in the document. So we're going to highlight all offers, contracts, or leases by licensees must indicate the business relationship the firm has with respect to the parties named in the document. And then you see it says 11:5 6-9. There, I'm going to put that in our slideshow. How about that? How about that? According to 11:5-6.9. What is that?
Administrative code.
That's correct. That's the administrative code. Right? Even though I got this open now, I'm going to keep this screen open so I can do some editing and you guys can watch it live here. All right. So yes, that's the administrative code. And then the next thing that we see here, it says we're going to highlight attached to a proposed contract of sale as the cover page must be the notice. What notice are they talking about in Breda?
Option 26.
Opinion 26. So let's
Opinion.
write that just above that sentence that we just highlighted. Opinion 26 notice. Now I'm going to back it up a bit just to that prior bullet point here on the slide that says they must indicate the business relationship with the parties named in the document. Okay, so that's New Jersey's requirement. I got a cross-reference here, page 184, section 29, or we could also say section 29 of the contract, section 29. I'll even give you a line number. Line number between 550 and 556. So let's actually go there. Let's go to page 184 for a second, or if you're in a different version of the book, go to the actual sales contract, section 29. So page 186 for 184 for everybody else. On page 184 of the actual contract. Okay. Hold tight for me for 1 sec, Paul. For anybody else watching this that may not have the book handy right now, I'm going to pull up an actual sales contract. So here's the, well, at the beginning, what needs to be cover page of any sales contract prepared by licensees? That would be the opinion 26 notice, right? So I have that right here. This is the opinion 26 notice. And what's the first thing we do? It's a disclosure of agency relationships where we're checking off who our agency's representing as of now. That's this area. Now, then the next thing says, so that said, that needs to be the cover page of any contract prepared by licensees. But prior to that, the prior paragraph said all offers, contracts, or leases prepared by licensees have to indicate the business relationship in the contract themselves as well, right? Now, what did it say, section 29? Look at this. Here's a table of contents of the actual contract. Section 29, what is it? Declaration of brokers' business relationships. And I said that's on line number 550, right? So you see these line numbers on the side of the contract, okay? First of all, anytime you're faxing or scanning and emailing contracts, make sure you look at the last number on the line, or the last number on the page, and then the next page should be the very next consecutive number. If it isn't, you need to call that other agent and have them send you a contract again because it's missing information. So I said this was on line 550, 550, right? So here we go. Section 550 to 556-ish. 557, 8, somewhere around there. All right, here's where this whole section over here, this is the disclosure of agency relationships, just like on the opinion 26. You're just checking off who the agencies are representing in the transaction, okay? Every document except for the lead paint addendum, which is a federal disclosure, requires the disclosure of agency relationships. I just want you guys to see what it looks like on all these contracts. It's just a checkbox where I'm checking off our agency's working with them as a seller's agent, buyer's agent, disclosed dual agent, or a transaction broker, right? And just like on the opinion 26 notice, look, they have that there as well. Every document that we have has that disclosure of agency relationships on it. Okay, I'm going to keep this open because we're going to eventually be filling out a contract, and we're going to use this as the example. I have this one that's already filled out, but and we'll do that according in the book as well. But in the meantime, let's just go back to the slideshow. So the next thing on the slideshow is, which goes along with the book's order here, where it says opinion 26 notice, and where it says opinion 26 notice here, I got a cross-reference. We just that's on page 174, so we could also write opinion 26 notice, page 174 in the book, where you already highlighted and wrote opinion 26 notice. All right, then the next paragraph, it says, New Jersey also requires that the following language appear exactly in this form at the top of the first page of the sales contract. All right, we're highlight that line or put an asterisk next to that statement, that sentence, and then there's a little paragraph there. You can either highlight the whole paragraph or just highlight the one line that you're probably going to see on exams as an answer option. This is a legally binding contract. And if you were to go to the first page in that sales contract, which is on page 198. Oh, wait, no, I'm sorry. That's the lease contract. On page 175, I'm going to write page 175 here as a cross-reference in my book. If you go to page 175, I'm going to go back to the contract here on the screen. This is on page 175 in the book. What does it say here under the New Jersey Realtors logo at the top of this page, the first page of the sales contract? What does it say here? It says, this is a legally binding contract. Right? That whole statement is there, but basically, this will be your answer option on exams if you see it, probably. Okay. So highlight this whole thing, or you could just highlight this is a legally binding contract on the actual contract itself on page 175. Everybody get that?
Yeah.
Everybody got it highlighted?
Yes.
All right, good.
Yes.
Now you can't tell me that I didn't tell you about it later on, because you got it highlighted too. I'll just reference to that page and say, see, you got it highlighted. I did talk to you about it. Okay. All right, so back to this. So we have a federal requirement too for any property built prior to 1978. We got that lead paint disclosure we got to give, right? It needs to be separate from the contract itself. But in the contract itself, we also have a disclosure that we supplied the information about the pamphlet and the lead hazard statements, etc. So, where does it say that in the contract? Let's see. In the book, there is a statement pertaining to that. Here, let me just look at this one here. Let's look at the table of contents. And it says lead paint or lead paint hazards. That's section 13 of the contract. So section 13 of the contract would be found on line number. So you see all the see all these section numbers here? Section 13 would be
207.
line 207, 208 around here, right? So this is the lead-based paint or lead hazard. See this? And then they have to check off whether it's applicable to this contract or not. What would determine whether it's applicable to this contract or not?
The year the house was built?
The year the house was built.
Two.
Exactly. So, what page number is this on in the book? The section, line number
78.
7208. It's on page 178, right? So I'm just going to give a little cross reference here where it talks about lead paint. Where does it talk about lead paint? Oh, we're not even at this point yet in the book. Oh, federal requirement for lead paint, page one, what did I say, 178?
Yeah.
Yeah, line 207.
Okay. Page 178, line 207 or 208, right? Okay. I wrote it in the wrong place. All right. So it's good to have the white out, right? Which you don't use on sales contracts, by the way. Shouldn't be whiting anything out on the contract. All right. Back to the slideshow. Next slide. All right, New Jersey contracts. They say that New Jersey requires the following statement be added to the top of the first page of any contract. It's a legally binding contract. We already went over that. Now, what is this statement saying? It says this is a legally binding contract that'll become final within 3 business days. During this period, you may choose to consult an attorney who can review and cancel the contract. So they could review the contract, make changes to it, or they could cancel it, okay? Now, all contracts by licensees must disclose the agency relationships as well. We got that on there. This is kind of reiterating what we already have here in the book. How does the attorney review process work? Well, most states and the southern parts of New Jersey don't actually use attorneys in transactions unless they have a problem. So attorney review, because their agents take a more active role and they do the term sheets, negotiations back and forth of the wording and how it's going to be added into the contracts and all the terms. And then they just, once everything's agreed upon, then they write the contract once. Here in the north central part of Jersey, the way we do stuff is when we make an offer, we actually write the contract. And because we do that, after the contract's been signed by everybody, we can't make changes later. Only attorneys can. So that has to be done during attorney review. So attorney review process, once the contract's been signed by both parties, what do we got to do? We first got to give them a duplicate original of that, immediately got to give them a duplicate original of that fully executed contract, right? So how does attorney review work? Well, after the parties receive their duplicate original is the counting of time. Now, this is the process here in the book on 172. Just highlight the title, attorney review. And then this is the process, these stages. They got it written here. We're going to be just watching it here on the slideshow. But this is what's in the book. So how does it work? Well, we start with the counting of time. After we give the duplicate original to both parties to the contract, whether it's for sale or lease, we have 3 business days to start the attorney review period. Otherwise, the contract becomes legally binding as it is. And then neither party can make changes to the contract unless both parties agree to them. Make changes or cancel, unless both parties agree to them. Now, during attorney review, this 3-day period can be extended or even temporarily halted by the attorneys or if both parties agree. Counting of time does not include weekends or legal holidays. I did say business days, didn't I? So to begin the attorney review, to make modifications or cancel the contract, otherwise it becomes legally binding as it is written. And then nobody can make changes without the other side's approval. Changes or cancellations without the other side's approval. So Notice of disapproval. So this is how attorney review works. Once both parties get their duplicate original, we send the contracts out to the attorneys, then get on the damn phone with the attorneys to call them to confirm that they received it, whether you sent it by email or fax. If it's email, your luck, they're going to end up telling you later, oh, I never seen it, I never got it. What email address do you have? We changed their email. It got caught up in spam. Something or other happened. Oh, the fax machine ran out of paper or ink or whatever the bullshit excuse is. Get on the damn phone as an agent. Don't be lazy. Call them up. Say, I sent over a new contract for your review. Your client is this, and whether you're the agent that's working with them as well. Let the attorney know who all the players are. I also send it over with a cover sheet on that contract that lays out who all the players are. It says in the middle, I'll have the mortgage company or the lender that they're using. On one side of the sheet, I'll have the the client's name, the seller's name, the seller's attorney's name, and then the seller's agent's name and contact information for all these people. On the right side of this sheet, I'm gonna have the buyer's name and all their info, their attorney's name and all their contact info, and their agent's name and all their contact info. And right in the middle of that sheet, there's the mortgage company, the mortgage rep, and all their contact info. So everybody, all the players in the transaction are in this one sheet, and you could see on this side is your players, on this side is your team, right? This is your team and that's your team. It's easy to distinguish that way. That's the way I put together my contact sheet anyway. And then I ask the attorneys to make sure that you copy us, copy the agents, please copy the agents, or please CC the real estate agents on all communications and all, or you could say all correspondence between attorneys during attorney review, to ensure that we stay informed, that we know, first of all, that the attorneys are communicating and that attorney review is progressing. Otherwise, that contract could just be sitting there and nobody's doing anything. You as the agent, it's our job to make sure we're not involved in attorney review, but it's our job to ensure that it gets started and that the parties are communicating. If they're not, you need to light a fire under their asses by calling their clients and telling their clients that their attorneys aren't doing anything. And can you call them and tell them, check on the status and tell them to do something, okay? So that they continue doing whatever they're doing. But before I go tattletale, I'm going to communicate with the attorney, okay? But then if the attorney's ignoring me, not communicating with me, I'm going to reach out to their client. Have their client call them. They'll be responsive to them. And then our job is to make sure that they keep communicating and that we get that letter saying that attorney review is concluded. See, we need all these communications in between too, because if they're making modifications to the contract, we as the real estate agents need to know what those modifications are. Because if they're going to require us to do something differently, wouldn't you want to know what it is that we need to do? Does that make sense? So be a proactive agent. This way your transactions will close, and your transactions will close sooner because everybody is doing what they're supposed to be doing. I know attorneys get busy. Sometimes they don't have the big staff and secretarial. It's just a one-man shop or one-woman shop. And maybe they have a paralegal, maybe they don't. If that's the case, they could take slower sometimes and have poor communication. So therefore, it's our job to light the fire, light that match under their butts, and make sure they're doing what the hell they're supposed to. All right? Now, so the attorney review letter goes out to one side, and the way the attorney review starts is with a notice of disapproval. Basically, an attorney will send out a letter to the other side that says something along these lines. We're in receipt of your contract for the purchase of 123 Main Street. However, we disapprove of the contract in its current format, but if you adopt our laundry list of suggested changes, which we have attached here, then we can conclude attorney review, and the attorney signs the letter and leaves a spot for the other side's attorney to sign. And if they sign it, attorney review is concluded. Or they send it out to the other side's attorney, then they have 3 days to respond to it. You see, attorney review is not 3 days. It's just that each party has 3 business days to keep communicating back and forth with each other, unless they extended that period or halted that period for some reason by agreeing. Okay, so then the other side has 3 days to review it, make any other changes, and send it back to the other side's attorney. And then they have how long? 3 days to respond to it, right? So attorney review is not 3 days, it's just 3 days to keep the communication back and forth, okay? That's what that 3 days. Attorney review, I've had it done in an hour, which was incredible. And I've had attorney review done in 3 months, which is ridiculous, okay? So how are the parties communicating too? So that's the notice of disapproval. That's how that works, okay? And when both parties are in agreements on all the wording that's to be entered in the contract and attorney review is concluded, they have now come to a meeting of the minds, right? They're in agreeing on all the terms. So both parties are signed it, or their legal representatives have signed it on their behalf after discussing it with their clients. Okay? Now, so the contract itself now, so that's how attorney review works. So the contract itself, I said, we don't write these contracts. They're already created. Listing agreements, we don't write these things from scratch. We have buyer's brokerage agreements. Here's an example on page 40 was the buyer's brokerage agreement, that exclusive buyer agency agreement. We got transaction broker and dual agency agreements. There's a sample one of that on page 47. Because we know that once you give somebody the, what's the first document you give to anyone you intend to do business with to disclose your agency relationships and to explain the different agency relationships? What's that document called?
CIS.
The Consumer Information Statement, the CIS, correct. Now, once we give that CIS form, if our agency is representing both parties in the transaction, can we work as dual agents if we just check it off on the CIS form?
Yes.
Not yet. That just says how we intend. We're telling our client how we intend to work as of this time. In addition to that, if we're going to be working as dual agents, we need to have them sign an informed consent to dual agency, which there's a sample one on page 47. Which,
So ultimately, there's 2 different things.
well, there's actually 4 versions. Oh, yeah, yes. And there's 4 versions of the dual agency agreement. There's one for a buyer, a seller, a tenant, and a landlord. But yes, we got to give them the CIS form. And if we check off on the CIS form, we're working as dual agents, we need to get them to also sign an informed consent to dual agent where the client is giving us permission for our agency. They're giving our agency permission to work in that capacity. We can't just tell them, hey, we're going to be representing both parties. We also need their written consent to do so. That would be the disclosed dual agency agreement. Here, let me minimize this for a second and pull one of them up for you. So, okay, so I got a bunch of them here. I got one for the buyer, one for the book I think only has the one for the seller in it. On the disclosed dual agency agreement, you got listing agency agreements. Here's an example of a buyer's disclosed dual agency agreement up on screen, okay? The book has one for the sellers. I think the only one they have in the book is for the seller. Here's one for the buyer. It explains how it would affect the buyer. So these are a little more customized. It explains the differences for them and how it would affect each party. This is why there's one for the seller, one for the buyer, a different one for the seller, a different one for the buyer. So they're not signing the same form. See, this one's only signed by the buyer's signature. There's no seller's signature on this. And on the seller's one, let me open that. On the seller's one, share the screen. On the seller's one, you see it says seller there at the top under informed consent to dual agency, has a property address. The wording's a little bit different in here, customized towards the seller. It has the seller's signature and their agents. See, the buyer's not signing this form, just like the seller's not signing the buyer's form, okay? Because these are specific forms for them to give permission to their specific agents or agencies to perform in that capacity with informed consent. And then we also have one for a tenant and for a landlord, as I'm going to throw up on screen right now. Here's one for a, oh, that ain't it. Here's one for the tenant, okay? Informed consent to dual agency for the tenant, okay? It says tenant at the top. And then tenant signature. And then I also have one for the landlord. And here's the landlord's one, okay? There's landlord. Okay? So they're pretty self-explanatory. You don't got to sit there reading these contracts to people, by the way. You just explain to them what it is. They can read it on their own time, all right? And then have them sign this stuff. Explain to them what it is. If you sit there reading contracts and every disclosure to somebody instead of just paraphrasing and explaining to them what these documents are and what they do, it's going to take you forever. It's going to take you hours on end to get a contract signed. What I suggest you guys do, let me give you a tip that will help you get contracts signed easier, okay, and quicker. You guys want a tip? You want a tip? Do you want a tip?
Yes.
We do.
All right, let me give you a tip here. The tip would be when you have your clients sign to get them to sign contracts, a good idea is before you ever find them a home, at the beginning when you start working with a buyer and you explain to them the home buying process, I suggest that you have a blank copy of all the disclosures and contracts that they need to sign and have it in a printed package already, some blank ones, and just give it to them. Say, now I want to give this to you because we haven't even started looking for homes yet, but at some point when we find that perfect home that you are interested in making the offer on, this is the actual contract that we're going to be giving to you. The only difference is these blank lines will be filled in. So I know a lot of times people get nervous about signing contracts. So I'm giving you these contracts in advance so that you can look them over. You could have your attorneys look them over and explain them to you if you like. And I'm just being open and transparent with you so that you could see what's in there. We're not hiding anything. This is going to be the same exact contract that you're going to be signing later. What did I say? You're going to be signing later. I'm also planting a little seed there that this is no big deal. You're going to be signing it, okay? But as I'm explaining this, you know, I'm also planting some words in there. I mean, yes, I am planting a little seed. You know, you're going to be signing this contract, okay, without being pushy. So this is the contract that you will be signing later when we find that perfect home for you, all right? I'm just giving you the opportunity that you could read through it in advance so that when it's time to actually put the contract together, all we really got to do is look at the blank lines and see the changes. So this way you're already aware of everything that's in the contract and I don't have to sit there reading it word by word to you, okay? So do a little homework and read these contracts. If you got any questions about them, you could ask me or your own legal counsel, your attorney about it, okay? And then this way you got it in advance. And now this way people are not scared of, wait, what's that? I don't know about signing anything. You know, they're hesitant on everything, or you're going to sit there trying to read them every word. Listen, I got better shit to do with my time. You know, I don't know about you guys. So just give it to them like that. And you're going to get people signing contracts like this. Boom. You know, remember this is the same contract. They're going to be like, oh, yeah. So where do I sign? Where do I initial? Okay, so you sign here. Okay, here's the blank line that explains this. Here's the blank line that explains that. You can see we're only filling in those blank lines. It's the same contract. So now they feel more comfortable too. Like it's not the first time and you're saying, here, sign here without me explaining anything. I gave you these contracts well in advance. You had plenty of time to look at it and see what's in it. There's no hidden whammies. I'm trying to get you to sign your life away to me or anything. You know what's in it. It's just a matter of what's on the blank lines that's changed. That's all you need to look at. And then sign here, initial there, sign there, right? And have them initial the bottoms of every single page. Because if we look at the contracts, let me pull that contract up again. So here's that contract again. See the bottom of every page in a sales contract, we put in here at the bottom of the page, buyer's initials, seller's initials, on the bottom of every page of the contract, okay? Do not leave any blank lines on a contract. Have them initial, not only here, but of course, if there's any lines within the contract that need to be filled out where information goes, have it filled out, okay? Do not leave blank lines in the contract. If there are some things that may not apply to your particular contract, then put a line through it, or fill it out. When you fill it out and you're doing it online, put all X's through it, or write N/A. You know what that means? Not applicable. It does not apply to this particular transaction. N/A, not applicable. All right. But look, there's plenty of check boxes here and there throughout there. There's plenty of lines where things need to be written. This is already at the end of the contract. At the end of the contract, on the last page, the buyer sign, the seller sign end dates, and the witness signature on this side. That would be you, or if you weren't present, whoever else. But is the contract still valid if it's not signed by a witness? Yes, it is. You need the buyer's and seller's signatures. Witness's signature is not necessary. The contract is still valid, even if a witness does not sign it. But I would still pull out my pen and I'll be like, let me just look over the contract, make sure you signed initialed everywhere. Okay, you did. All right, now let me make it official. And I do my sign. I do my little Ed Norton thing there. Honeymooners. No, whatever. Okay. And there's all kinds of other notices here, wire fraud, blah, 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 blah. Okay, so anyway, these are the basic contracts. Now, I printed this out a little bit while ago. You know, if I printed a newer one, there's also a coronavirus notice in these things too. Trying to avoid lawsuits and such, we actually have coronavirus disclosures now too. Because if somebody is selling and they had coronavirus, or they died and you're selling the house of somebody who had coronavirus, we want to make sure that they're not going to end up suing us later because they got coronavirus because it was in the house still or something. Who the hell knows, you know? So we got a disclosure for that, you know? Whatever's trendy. Wonder if they had an AIDS disclosure back in the 80s, you know, until they signed it into law that you can't discriminate on somebody based on that, which, by the way, they did in New Jersey now. That's been attached to even since this book is brand new, that just came out, the Attorney General's memorandum, there's a supplement to it. I don't think they updated it yet, but they added another protected class, and that is, well, I mean, people who are sick or that have illnesses, but that they added also includes those with coronavirus or COVID-19. All right, so contracts, back to here. So we have that disclosed dual agency agreement, sales contracts. Where am I at? Okay, so the contract form. All right, on page 187. Page 187. There is no official name for the contract. So you could call it sales contract. You could call it whatever the hell you want. Basically, there's no official name for it. So next to where it says sales contracts, just write no official name for the contract. You could just call it the contract. Okay. Okay. So there's no official name to the sales contract. You can call it whatever the heck you like. Okay. It goes by many names: sales contracts, purchase contract, offer to purchase, contract of purchase and sale, earnest money agreement, binder and deposit receipt. It goes by there's many variations to what people call it. Basically, it's saying don't be so righteous because you prefer calling it something. There is no official name to it, or one that's more correct than the other. Okay. So on page 187, now under that, it talks about offer and acceptance. So how does that work in real estate contracts? How does that offer and acceptance process work in real estate contracts? Well, so where we leave off here, offer and acceptance. How does offer and acceptance work in a real estate transaction? The offer and acceptance, that's one of the essential elements of a valid contract. So how does it work in real estate transactions? Well, see, in negotiations, an offer is not considered accepted until the person who made the offer had been notified that their offer had been accepted. Okay. Delivery, acceptance, and signatures are not required for an offer to be accepted, but it's always recommended that you follow up with getting it in writing. Let's read how this process works. So, one of the essential elements of a valid contract of sale is a meeting of the minds, whereby the buyer and seller agree on the terms of the sale, and this is usually accomplished through the process of offer and acceptance. So a broker lists an owner's real estate for sale at the price and conditions that are set by the owner. A prospective buyer is then found who wants to purchase that property either at the seller's terms or their own. So an offer is drawn up, signed, and the prospective buyer by the prospective buyer and presented by their broker to the seller. This is called an offer. Now, if the seller agrees to the offer exactly as had been made and signs the contract, then the offer has been accepted and the contract's valid pending attorney review. So the broker then must advise the buyer of the seller's acceptance, obtain attorney review if the parties wish, and deliver a duplicate original of the contract to each party with all the final ratified changes. Any attempt by the seller to change the terms proposed by the buyer creates what's known as a counteroffer. Now, a counteroffer is in essence a rejection of the offer that had been made, right? So the buyer's relieved of their original offer because the offer had been rejected. So at this point, what can the buyer do? If they made an offer and the seller makes a counteroffer, what are their options? Well, they could just walk away. They could accept the counteroffer. They could counter the counteroffer, right? So they could accept the counteroffer. They could counter the counteroffer. They can walk away. They don't have to do anything. Or they can accept that offer that had been made, right? So the buyer can accept the seller's counteroffer or reject it. If they want, they can make another offer. Any change made in the last offer results in another counteroffer, right? Anytime you make a counteroffer to somebody, you're basically saying, I'm not accepting your offer, I'm making my own again. And so the other party's not obliged to even continue this conversation. So an offer is not considered, we're going to highlight this on page 188. An offer is not considered accepted until the person making the offer has been notified of the other party's acceptance. And I want you to write above that, just like we have here on this slide, this last sentence here. Delivery, acceptance, and signatures are not required, but recommended. That's pertaining to contract negotiations. When you're negotiating with someone, when is your offer considered accepted? Simply when you notify the other party that it's been accepted. That could be verbal. However, it's not good practice to rely on verbal. So you should always follow up with getting it in writing. However, for exam purposes only, when is an offer technically considered accepted? Simply upon notification. Okay, so you guys highlighted that first sentence on 188, and you wrote delivery and acceptance and signatures are not required but recommended. Okay. All right, earnest money deposits or good faith deposits, what are they? Well, it's customary when you make an offer that offer is accompanied by a minimum of $1,000 good faith deposit for the buyer to show the seller that they're operating in good faith and they mean to carry through with this transaction to the end. And if it shows that they're not operating in good faith, that the seller can make a claim against any deposit money that they made. It's to prevent the seller from just the buyer from just walking away, or from from making offers on 10 different properties and seeing what sticks, basically. So highlights earnest money or good faith deposit gives evidence of the buyer's intentions to carry out the terms of the contract. Now, when people make good faith deposits less than $1,000, I don't take that seriously. I coach the seller not to either. You should have a minimum of $1,000. If somebody's like, okay, I'll give $50 or $100, something's wrong. You're making an offer on the property and you don't have $1,000 to put down, you're gonna need a lot more money than that. So something shows me that they're not operating in good faith right off the bat, just by how they're acting. So let's see, the deposit's given to the broker, and the sales contract typically provides, not typically, but it could provide that the broker or seller hold the deposit until closing, and if the offer is not accepted, that earnest money deposit is returned to the would-be buyer immediately. Well, that's true, but it doesn't provide that typically provide that the seller or the seller's attorney holds the money. We, as the buyer's agent, we got it in our escrow account. They would have to word it in there, and then we'd have to transfer it to them only if the buyer agreed to that. I say use caution on that, because I've noticed that when sellers request that the deposit be kept in their attorney's trust account, if something falls through in that transaction, sometimes they say, you know what, let's make a claim to keep it. They'll have to fight to get that money back, and it's not worth it for them to do that. Had experiences with that before. So use caution when the seller wants to hold the deposit money. Just say, no, it's secure in my broker's account. The money's there. They'll lose their license if they say it's there and it's not. The money's there. But no, we're not going to turn it over to you. We're gonna hold on to it until we're in a legally binding contract here, and then we'll go from there. All right, so let's see. The amount of the deposit is a matter to be agreed upon by the parties. I suggest $1,000 minimum good faith deposit. So generally, the deposit should be sufficient enough to discourage the buyer from defaulting and to compensate the seller for taking their property off the market and to cover any expenses the seller might incur if the buyer defaults. A purchase offer with no earnest money deposit, however, is valid. But I would advise my client not to accept it. Now, highlight contracts can provide that the deposit becomes the seller's property if the buyer defaults as liquidated damages. That's only if they wrote it in there. not all contracts have a liquidated damage clause in them. And if they do, we read before, liquidated damages is the amount that's going to serve as compensation. They cannot sue for money beyond that amount. So earnest money, we're going to highlight, earnest money must be deposited by a broker within 5 days in a special trust or escrow account. Money cannot be commingled, mixed with the broker's personal funds. This is an illegal act known as conversion. Right? Brokers converting it to their money when they spend it, right? So a broker cannot use those personal funds, the escrow money, that deposit that somebody else gave. That's called conversion when they do. It's theft, but it's conversion. All right. Broker doesn't have to open a separate escrow account for every client. They could have one escrow account. It's a bank account where we keep other people's money. It's a non-interest bearing account, as we learned in chapter 3. They just need to keep escrow books to keep track of all the money that's in the escrow account. Go down to the next sentence after this paragraph and highlight, any cash deposits $10,000 or more must be reported to the IRS. Does any of this sound familiar to you?
Yes.
This is stuff that we went over in chapter 3, right? So here's some of the parts of a sales contract that are, here's some of the things that are in your typical sales contracts. First of all, the contract has to be in writing. Got to have competent parties. There has to be an agreement to buy and sell. There has to be an adequate description of the property in question. Consideration, the full price, the legal tender, exchange of value or love and affection if it's a gift. Grantor's agreement to convey the property. Place and time where the closing is going to take place. Signatures of the parties with their initials on every page. If you don't initial the bottom of every page, and what's to stop somebody from replacing that page with something else? Here's some of the non-essential parts of a valid contract. Encumbrances to which the deed will be made subject to. A lot of properties don't have any, you know. Earnest money deposits, they're not required, but I highly suggest it. Mortgage financing, the buyer plans to obtain, and other contingencies, well, they can be buying cash. Possession by the buyer, when can they get the possession by? Title evidence, what kind of proof of ownership do they want? Prorations and adjustments. Destruction of the premises, that's why we do the final walkthrough. Default by either party, final walkthrough, you do that on the day of closing. I guess that should have been up here. The destruction of the premises. Contingencies happening to which the contract is dependent on or subject to. They can be added into the contract. The final walkthrough actually should probably be its own additional bullet point. Let's get a little more room here. We know that final walkthrough, we're going to do that on the day of closing, right? And the contingencies are happening which contract's dependent on, and signatures of a witness are not required for a contract to be valid. So what are some of the common contingencies added into contracts? Well, first of all, what is a contingency? A contingency is a happening on which the contract is dependent on or subject to. So you often may hear this referred to as a subject to clause. The property is subject to the buyer obtaining financing, a mortgage loan, subject to a home inspection, subject to relatives who are going to lend me money to buy the house, getting their approval, subject to the sale of my current home. So if I don't sell my current home, how can I go through this one? Or if it's a short sale, subject to third-party approval. There's a lot of subject or contingencies that can be added into contracts. Subject to me getting the permit from the city to use the property for the purpose that's intended. If I can't get the permit to use the property for a certain business use, for example, I don't want to go through with the purchase. Developers, subject to us getting the approvals from the city to build our project. If they don't get all those approvals, if they don't get their financing, if they don't get everything that they need, well, then the land purchase was subject to those things, and it's a way for them to get out of it. So agents should always address and remove contingencies in a timely manner as soon as possible. Home inspection contingencies, for example. After it's out of attorney review, immediately schedule that home inspection and appraisal of the property. Let's do the home inspection first, though. Mortgage. It's subject to a mortgage, them getting that financing, that mortgage commitment letter. Subject to an appraisal, okay? If a property financing is getting, the purchase financing is coming from the FHA or VA, these types of loans require that the purchase contract has a special contingency clause added into that contract. You have to know what is the, for exams, you have to know what is the purpose of the special contingency clause that's required by all FHA and VA loans to be added into purchase contracts. Well, it says that if the property does not appraise for the purchase price, then the buyer can get out of the contract without penalty. Okay? It's required to be added to the contracts. Now, approval by a family member helping with financing or down payments. Okay, hold on a second. Let me take a look at something real quick. Here is the special contingency clause that we add in. It's just a separate document that we add into the contract and make it part of the contract when the financing is coming from the FHA or VA loans. And then it's signed by the buyers and the seller, okay? But this is basically the clause right here, okay? The addendum is attached to and made part of the New Jersey contract. If this addendum conflicts with the contract, then the addendum shall control, okay? If the buyer is applying for a VA guaranteed mortgage loan or FHA insured mortgage loan, then the FHA VA form of a mandatory clause and certification is attached, except that if the buyer or lender requires a different form, then buyer and seller agree to execute and deliver that form. Okay, because the law, federal law, requires that these additional contractual provisions be added in to that contract. All right, approval by family members. Look, I suggest this. Anytime there's going to be contingencies added, try to create that contract as contingency-free as possible. The more contingencies added into a contract, the contingency is just another way out that somebody has to get out of the contract. So I suggest that you guys, when putting together contracts, that you put together contracts as contingency-free as possible. Because in a multiple offer situation, the contract with the less contingencies in it is the more desirable contract for the seller. So if you have your contract that's loaded with contingencies, which one is the seller you think going to accept? The one loaded with contingencies or the one with very few? Probably the one with very few. It's more likely to go through. The buyer's less likely to back out. Also depends what those contingencies are. If you got family members that are helping with the down payment or the money to buy the house or closing costs, and they need to give their approval of the purchase in order to go through with that. Well, we need to know that, because then we would try to get them through the house before you ever put the contract together. Get their approval beforehand. So you don't have to add that as a contingency for the contract. But if you weren't able to do that, you better make sure that you do add it to the contract. Because if that buyer later wants to back out because their relatives don't agree to the purchase, that's not a reason to back out. And you didn't specify it in the contract. So if the buyer backs out, they're going to be in breach of contract. All right. So I suggest that you get them to go through the house first instead of writing a bunch of names down. Look, I've had this happen before. I had 3 carloads of family members that were helping to give the money towards purchasing the house. I had 3 carloads of family members that had to give their approval. I'm like, I ain't writing all these names down. I'm like, let's set up an appointment. Let's meet everybody at the house. Let's go through the house, see if everybody approves of it or not. Save me the effort of having to put the contract together and having to put contingency clause in for with all their names, then still having to get them to go through the house anyway, and then removing the contingency. Just get them through the house to begin with. Plus, it makes your offer seem better, right? So, and I got 3 carloads of people that went through that house, and I still had to put a contingency for 2 people who were driving down from Canada. That was a little crazy situation. But when they came down, I got them through the house and removed the contingency right away. Sometimes you have no choice to add contingencies, but you have to do it to protect your clients. So if I didn't add that in there, those people came down, they're like, oh, no, we don't agree to this house. And then the buyer backs out, then they're in breach of contract. All right. If the purchase is subject to the sale of the buyer's current home, maybe they already have a house that they own that they need to sell first. Or they have a lease that they need to get out of that the landlord won't let them get out of. So subject to the ending of the lease, or subject to the landlord letting them out of the lease early, what have you. If a buyer puts a home sale contingency clause in the contract, basically says that this purchase is subject to the sale of my current home first. If that's the case, and I'm the seller's agent, I'm always going to ask that they add in one of these, an escape clause, which also sometimes is called a kick-out or knockout clause. What does an escape clause do? Well, it says that in the event that a buyer puts a subject to this purchase is subject to the sale of my current home, I'm going to want them to add an escape clause in there that says, okay, we'll accept this offer, provided that we're allowed to keep the property on the market for sale and showing it. And in the event we get another buyer who makes an acceptable offer, that we'll come back to you and ask you if you can remove that contingency. And if you're not ready to remove that contingency, that this purchase is subject to the sale of your current home, we could cancel the contract with you so that we could accept the other one and not be considered in breach of contract. Okay? So if you want us to accept your offer contingent on the sale of your home, we're going to want you to accept the terms of an escape clause. So who does the escape clause protect?
Seller.
The seller. Correct. You need to know that for exam. And it's also not a bad idea to know it just for working in the business, because sometimes people sell homes and or buy homes and they make them subject to the sale of their current one. So if you're going to buy a home and make it subject to the sale of your current one, I suggest that in that offer that you're making, you also write the status of that current home. Is it even on the market for sale yet? Is it under contract? Is there an anticipated closing date? What is that anticipated closing date? You think that'd be some relevant information that the seller may want to know when going over and trying to figure out when contemplating if they're going to accept your offer. Expiration of the buyer's lease when they're where they're living now. It could be subject to a use permit, subject to building permits or construction, and subject to third-party approval, such as with short sales, bankruptcy sales, foreclosures, whatever. All right. So under contingencies in the book, let's highlight the first sentence that talks about the FHA VA special contingency clause. In the second paragraph, just highlight the term subject to, because that's sometimes what it's subject to is. It's a contingency. It means whatever this is, it's going to be a contingency. It's subject to. Go down 1, 2, 3, 4, 5, 6 lines in that second paragraph and highlight on that same line where you see the word contingency in bold, highlight where the purchaser has another home that must be sold first. The seller may insist on an escape clause, also called a kick-out or knockout clause. And then I would write in the margin next to it, protects the seller. Who does a kick-out, escape clause, or knockout clause protect? The seller. And then you already have liquidated damages highlighted there. We highlighted it earlier, right?
Yeah.
Yes.
Okay. So here's some of the clauses we already went over. These are contract contingency clauses that could be added in, the FHA, subject to engineering reports, escape clauses, liquidated damages, short sales, obtaining permits, ooh, yada, yada, yada. We just went over a bunch. Okay, additional contractual issues in the page. New Jersey has a plain language requirement for contracts that has been reduced to a little blurb. It used to be a full page in the book. That says that New Jersey contracts for purchasing real estate have to have a plain language requirement, meaning that you have to use words that are common in the everyday English language that do not have a separate legalese meanings to them. However, that only applies to properties valued under $50,000. Well, they're far and few in between in New Jersey, aren't they? So that doesn't apply. So most of our contracts do have legalese. All right, rescission of a contract. What does the word rescission mean? It's your right to cancel a contract within a given period of time. Have you guys been studying? Because I gave you I think on the first day, a bunch of different rescission periods for various things. What is the rescission period for resale properties? Anybody? 3 days, that's your attorney review period. What is the rescission period for new construction for out-of-state properties marketed to New Jersey residents?
5 days?
7 days.
Some days.
What is the rescission period for new construction for the discovery of off-site conditions?
5 days.
5 days. What is the rescission period for new construction, large in-state subdivisions, or if they're under, that are 100 units or more, or if they're under 100, they have common area elements?
10 days?
7 days. It's 7 days.
7.
What is the what is the rescission period for mortgage loans to refinance property that somebody already owns? Three days. What is the rescission period for purchase money mortgages? That's any loan used to buy real estate. Big fat 0. 0 days. All right, got to study them rescission periods. Got to study your notes. Okay, option agreements. Who could prepare those? Only attorneys. They're unilateral contracts. Land contracts, well, this is coming up. I'm going to go over and give you a nice big long definition for that, what a land contract is. But it's basically a type of seller financing where the owner does not turn over the deed to the property to the buyer till the buyer's paid off a predetermined agreed amount or the full amount. And therefore, the buyer is not the owner. They're not given the title to the property or the deed to the property until the full amount owed is paid. But the buyer does have a financial interest in the property that's called equitable title. All right. Anybody ever hear this word equity before? Equity, you know what equity is? E-Q-U-I-T-Y, equity. Equity
Yes.
is the difference
Between
between
the price.
the market value and what's owed on it. Equity is the difference between the market value of the property and what's owed on it. There's different ways that you could build equity. Paying down what you owe. You're widening the gap between the market value and what's owed on it. So you're getting more equity. It's built in value is another way of saying it. What's another way you could build equity? Well, you could force it by doing improvements on the property. You do improvements, aren't you raising the market value of it?
Yes.
All right. Or just do nothing. Markets fluctuate. They go up and they go down on their own. If you're in one of them upswings, your property value can be going up with you not doing a damn thing to it. And if that's the case, you're building equity. Right? So those are different ways equity can be built. But this is equitable title. Title meaning ownership. And the buyer is building equity as they're paying it off. So even though they're not the owner yet, they do have equitable title. They have that means they have a financial interest in the ownership. Okay, so what is the right of rescission? Here's all those rescission periods that we just ran down a minute ago. Okay. I think this was also in chapter 2 or chapter 1 or chapter 2. We went over this as well, and I had it in no slideshows. What is rescission? What are the rescission periods for contracts, sales contracts? And then what are the rescission periods for lending? All right. Additional contractual issues continued. So here's the land contract that I just explained to you. But do not confuse it with the ground lease that we're going to learn about later on. Obviously, it's not going to be on page 175. It's going to be much later. That is not right. So that'll be somewhere in chapter 12. Ground lease. I got to give you a cross-reference on this. Page 215. Let me just check 175 and see if it was also mentioned back there. I don't think so. Nope. So this was for chapter 13 book. So this should be 215. Let me go there, make a change on that. Page 215, we talk about a ground lease again. save that page. Full screen. And share the full screen. Okay, so additional contractual issues. So a land contract. What is a land contract? I say, first of all, do not confuse it with a ground lease. What is a ground lease? A ground lease is where a landowner rents their land to somebody and then they construct a building on it. That's not what a land contract is. A land contract has to deal with seller financing. I just explained this a few minutes ago. It's also known, it also goes by the name of an installment sales contract. It's basically a lease to own, where the buyer makes payments in installments and the seller does not give them the deed for the ownership, to turn over the ownership, to transfer the ownership until the full amount owed has been paid or some other amount that they pre-agreed upon. Now, until the buyer pays off that full amount, they don't get the ownership. However, they do have a ownership interest, a financial interest called equitable title, even though they don't yet own the real estate. So what if they stop making the payments to the seller? Well, they're not the owner of the property, so they can't get foreclosed on like a bank would foreclose on you for not making payments. So it's easier to get you out than foreclosure. However, you're also not just a renter. So it's harder to get you out than evicting a tenant. So it's somewhere in between foreclosure and getting rid of a tenant. All right. It depends on what all the terms were that were written into the land contract agreement. And no two of those are probably alike. So if you ask me any questions about how this works, my answer is going to be, I don't know. It depends on each individual agreement, which is different. So here's your definition of equity again. It's the difference between the market value on a property and what is owed on it. It's built-in value. You can get it by paying down your debt. Market values rise on their own, or you could do improvements and force equity buildup, right?
So this would apply only to rent to or lease to own types of scenarios, correct?
Well, land contracts is.
Right.
Word equity, no, not necessarily. This also requires, if you bought a property and you own it, all right, how do you build equity? Well, if you got a loan, an outstanding loan on the property, well, there is a difference. You got to calculate it. It's the difference between the market value and what's owed. If you have no loan on the property and the house is paid off, you have all the equity in the property. There's nothing owed on it. So whatever the market value is, that's your equity. Okay? Good?
Yes, yes.
Okay. So. So we went over some stuff on page, let's see. We already went over page 187, page 188. What's the last thing that we highlighted? Page 189? Oh, page 190, down the bottom, land contract. You're going to highlight the title, land contract, and then highlight land contracts, sometimes called an installment sales contract. Land contracts are typically used as a means of seller financing. Then go down 1, 2, 3, 4, 5 lines from that. And we're going to highlight, although the buyer obtains possession when the contract is signed by both parties and the buyer has equitable title. The seller does not execute and deliver a deed to the buyer until the terms of the contract have been ratified or satisfied. That means they pay off the full amount that's owed. Mhm. Let's see. Now, rescission of contract under that one on page 190. Nothing in particular to highlight there. Use this slide that I gave to you guys that has all these rescission periods to study from. Otherwise, they're spread throughout the book. So, I mean, you should understand what rescission of a contract means, okay? And what all these rescission periods are. Well, actually, one thing you can highlight in this section, the last two sentences there that say, the borrower who changes their mind about a mortgage loan has 3 days in which to cancel the transaction if the mortgage was for refinancing presently owned property. No right of rescission, however, applies to loans used for the purchase of real estate. Oh, good, they reworded it there. And you could write purchase money mortgage after that. What is a purchase money mortgage? It's any loan used to buy, to purchase real estate. If you were to read that backwards, let's first write that there. Purchase money mortgage. Purchase money mortgage. Read it backwards. Mortgage money purchase. Mortgage money to purchase. That's all a purchase money mortgage is. It's any loan, including seller financing, which is a loan that's used to purchase real estate. However, when you already own real estate, there's a 3-day right of rescission for loans to refinance. What is refinancing? It's basically you're getting a new loan to pay off your existing one at a lower interest rate, hopefully. So option agreements. Option is a contract. Who can prepare option agreements?
Attorneys.
Only attorneys.
Only attorneys.
All right, so let's just highlight the title, option agreements. And then the very last line, should be prepared by attorneys. Otherwise, you're practicing law without a license. And you don't want to do that. All right, so what we're going to do now is let's do the key terms to review. Let's do the key terms to review. And then we're going to back up and fill out the contract. I'll show you how to fill out a contract, okay? So key terms to review. Number 1 on page 192. Agreement between two parties to perform some legal act.
Contract.
Contract.
Bilateral.
7 is A, it's a contract. A violation of a contract.
A breach of contract.
Breach of contract.
3 is B, breach of contract. Buyer's deposit with the purchase contract.
Earnest money.
Earnest money.
9 is C, earnest money. Certain happening on which a contract depends.
Contingency.
It is a contingency. 6 is D. A contract not put into words but shown by actions.
Implied contract.
An
Implied.
implied contract, 15 is E. A contract that's set down in so many words.
Express.
Yes.
14 is
Express
F, an express contract. A contract that has been fulfilled.
Executive.
Security contract.
12 is G,
Executed.
executed contract. Contract that has not yet been performed.
Secretary contract.
Security.
Executory contract, 13 is H. A contract with a promise by each party.
Bilateral contract.
Bilateral contract, 2 is I. Interest acquired by a buyer with a land contract.
Equitable title.
Equitable title.
10 is J, equitable title. Offer returned to buyer with changes by the seller.
Counter offer.
Counter offer.
8 is K, a counter offer. Protections for a seller when a buyer has another house to sell.
Escape clause.
11 is L, escape clause. What does it also go by?
Kick out.
Kick
Knockout.
out or knockout,
Knock out.
right? So 11 is L. Something of value given in exchange.
Consideration.
Consideration. 5 is M. Those legally qualified to enter into contracts.
Competent parties.
4 is N, competent parties. Transfer of interest in a contract to a third party.
Assignment.
1 is O, assignment. An agreement under which the buyer pays in installments and they wait for the deed.
Land
Land
contract.
contract.
Land contract, 16 is P, right? And land contract is also known as, has it in the definition, a little hint,
Paper title.
an installment
Contract for deed.
sales contract. Because they're making their payments in installments and then they wait for the deed. So it's basically a rent to own situation, right? Right. Okay, great. Okay. So, I'm trying to mark my page here. Sticker makes life easier. All right. So, a contract binding one party, the other party's free to act or not.
Option.
4 is A, that's describing an option, correct. A seemingly valid contract that neither party can sue to force performance. Neither party can sue to force performance.
Unenforceable contract.
11 is B, unenforceable contracts. A contract clause requiring punctual performance.
Time is of essence.
And
Time is of the essence, meaning it's very important. 10 is C. A return to the status quo. That means returning back to the way that you started.
Rescission.
Rescission, 6 is D. A contract that does not meet all the legal requirements.
Void contract. Void contract.
Voided contract.
14 is E, correct. A contract that's binding, but one party may disaffirm it.
Voidable contract.
Voidable contract.
Voidable, 15 is F. A contract that meets all the legal requirements.
Valid
Valid
contract.
contract.
13 is G, a valid contract. Court action usually asking that the seller be forced to sell as agreed in the contract.
Specified performance.
Specific
Specific performance,
performance.
7 is H. Time within which one is allowed to assert their legal rights.
Statute of limitation.
A statute
Nine.
of limitations, 9 is I. A law requiring certain contracts be in writing.
Statute,
Statute of frauds.
8.
8 is J, statute of frauds. One-sided promise, valid only if the other party acts.
unilateral contract.
Unilateral
12
contract.
is K, the unilateral contract. A convention that written contracts override spoken promises.
Parole evidence.
Parole evidence rule, 5 is L. A substitution of a new contract with an existing one, or for an existing one.
Novation.
Novation.
That's written weird. 2 is M, novation, yeah. It's actually substituting an existing contract with a new one. This is substitution of a new contract for an existing. That's weird the way they wrote that. 2 is M. So some agreed on to serve as damages in case of future default.
Liquidated damage.
Liquidated damages, 1 is N. And the meeting of the minds is also known as
Offer and accept.
Offer and
RICO, offer and acceptance. Okay. So let's go to the first page of the sales contract, which can be found on page 175. So what do we got to do when we prepare contracts? Oh, we got a lot to do. That. Well, we're going to have a couple windows open on your computer anytime you're preparing a contract, okay? One, you're going to open up this website, njrforms.com. That's a shortcut I made to basically njrealtor.com/zipforms. And then there's another link you got to click on when you're on that page to get to the contracts. Or you could just click on njrforms.com, which basically is a domain name that I bought and I pointed to the right place. It takes you there every time. So it opens up the digital contract form system that we have. Then you're also going to open up either through the MLS. You can open up the MLS and have a tax window open for their tax system. And you're also going to open up the listing so that you could get all the information from the listing. So we're going to need the tax records open, the contract system open, and the actual listing available for us. And we're going to need another window open to gather the other agent's license numbers. Here's the link that I gave you guys to that. The tiny URL I made. Actually, I bought a domain name too for that now, so that we can make sure it's always there. But let's open this up. If I click on tinyurl.com/NJRE license search, it will bring up got a browser window. It's supposed to be opening. Come on, come on. Open, open, open. All right, maybe I should just copy and paste it. Oh, here it goes. It's opening ever so slowly. But nonetheless, it opened. It brings up this page, and on this page, this is the Department of Banking and Insurance, Real Estate Commission's licensee search page. Here's where you put in the name, the last name, and if it's too many names or it's a common last name, you may want to put a comma in there and then put the first initial of the next person or put in their full name and do a search so that you can get their reference number, which is their license number, because you get all contracts now We're going to need the license number of the brokerage, which that would be the EMP reference number. That's short for employer reference number. And then the agent's license number, which is referred to for some reason as a reference number in their database there, okay? So yes, that's my license number, and here's one brokerage that I have, and here's the other brokerage, okay? So you could search in this database to find out if somebody's actively licensed or not, but you could also get the information for their brokerage firm, and then you're gonna need to enter all that information with their license numbers onto our actual contracts. That's what you need to do these days, because if we look at this contract, the actual contract, there's a section where we got to put down everybody, all the agents' information and the commissions and such. Okay, see here, listing firm name and the license number, listing agent and the rec license number, the address for the agency, not your address, and the office phone, fax, and the agent's cell, and email. And then you put in the commission that's due the listing firm, which you get that from the listing, and how much commission is due for the participating firm as well. You would put down the license ID of the participating firm and the name, participating firm's agent and their license number, office address, phone, fax, agent cell, email, and the commission that's due to the cooperating or participating firm. All right. This is interesting. Under New Jersey law, this is something I haven't read before. Apparently it's in the contract. Equitable lien. Under New Jersey law, brokers who bring the parties together in a real estate transaction are entitled to an equitable lien in the amount of their commission. This lien attaches to the property being sold from when the contract of sale is signed until the closing, and then the funds are due to the seller at closing and is not contingent upon the notice provided in section whatever. As a result of this lien, the parties who disperse the funds at the closing in the transaction should not release any portion of the commission to any party other than the brokers. If there is a dispute with regard to the commission being paid, should hold the disputed amount in escrow until the dispute with the brokers is resolved and written authorization to release those funds. Okay. Pertaining to, I guess, they didn't pay the right amount of commission. All right. So we're going to have a lot of windows open here. We're going to need, who prepares these actual contracts?
A lawyer?
Well, you're the agent. You're going to prepare.
Broker?
But which agent prepares this contract? Is it going to be this listing agent or the buyer's agent?
List.
Listing agent.
Listing
The
agent,
buyer's agent.
the buyer's agent.
Listing agent did all the work putting the listing in. You're the one that's making the offer. You're the one that writes the offer. Okay?
The buyer's agent.
So if you're the buyer's agent, you're the one that's preparing this. So you're going to need to have that pre-qualification or hopefully a pre-approval letter by now in hand. If the buyer's purchasing with a cash purchase, they're going to need a proof of funds letter from their bank, not stating how much money they got in the bank, just stating they have enough money in the bank to complete this purchase. So we're going to need that letter that states the amount, which would be enough for this purchase, whatever the purchase price is. A lead paint addendum from the owner that we had to already obtain. If in the listing agent did not put that in the listing, the lead paint addendum, you're going to need to call up that you could download and just print out and have the buyer fill out that's already been filled out by the seller. If they did not upload that into the MLS system under the additional documents section, then you're gonna need to call the listing agent, tell them you're putting together an offer, and you're gonna need them to fax over to you or email you the lead paint addendum that was already filled out by the seller. You're gonna need a seller property condition disclosure report. If they had one, they should, hopefully. You could find one on page 154. Hopefully that's the right number. Yep, that is. And the buyer and seller's attorney's information, because you're going to need to gather that information to send this contract to everybody after it's been signed and accepted by and fully executed, right? Now, a mortgage commitment letter that should be produced within 30 to 45 days. Okay, so on page 175, we're filling out the contract, the first page of the purchase contract. It's pretty self-explanatory what you put on it. Okay, here, what we're gonna do is, see, I have these things written here, what we put on it where. Let me bounce back and forth. I'm gonna go to the sales contract here. Let's go to the first page in it. That's the cover page, the opinion 26. Let's go to the first page of the actual contract. It's pretty obvious what you put on these pages, right? Look, what goes on these lines? All the buyers' names, right? Whose address you put their address or addresses where they live, which could be different. Well, the address is where they currently live, not the address of the house that they're looking to buy. And then they agree to purchase from, and you put all the sellers' names here with the address where they currently live, which could be different than the subject property that the buyer is making the offer on. That goes here. See property address? This is where all the information about the property goes. So here is where you would type like 123 Main Street. And you don't put the name of the town on this line. That goes on the next line where it says shown on the municipal tax map of, and you would write the name of the municipality here. Okay. You guys should actually be doing this in the book here. Over here on this line, you should write, on this line where it says property address, you should write subject property on that line. Or subject.
Wait, what? Subject?
Subject property address. How about that?
Subject property, yeah.
Okay, I'm gonna see if I can do it with you. No, I can't on this one. This one's not editable. So you're gonna write subject property address here. And then where it says shown on the municipal tax map of, you're gonna write municipality name. You write the municipality name here. And I want you to highlight this, county. Do not leave that blank. We have multiple municipalities in the state of New Jersey that share the same name. You have to look up and specify what county this property is in. Don't be lazy.
So on the municipal tax map would be the name of the town, right?
Yep, so the name of the municipality, the name of the city, town, township, borough, that's a municipality. So write name of municipality on this line, and followed by the county. Highlight that because you don't want to forget to fill out this place right here. That needs to be filled out, okay?
Okay.
And then you get the lot and block number from either the MLS listing or the tax record. Remember I told you, you got to have those multiple windows open to get that information. And you'd also get the county from there too, from the listing or the tax record as well. County, not country. We know we're in the United States. We're selling in the United States. We need to know the county. All right. Now, here's the important part. The moolah. We're going to prepare this contract here in the book for a property that's $300,000, and the buyer's using an FHA loan, which requires a minimum 3.5% down payment. So that's what we're going to go with on this transaction that we're preparing. So on the line that says total purchase price, I want you to write $300,000. And then line below it where it says initial deposit, what should we always make as an initial deposit? Minimum $1,000 good faith deposit when submitting the offer. And if that offer is accepted, well, if their lender's requiring 3.5% down, they're going to have to put at least 3.5% down. And on a $300,000 house, that would be $10,500.
That's
So
3%,
that would be-
9,500.
That would be 3.5%. So if we have a $300,000 home, so this is why you guys are going to need to bust out with a calculator when you're doing this too. Actually, you really don't, depending on where you're getting the contract. If you're doing this online through the contract form system, as you type in these numbers, it does the calculations for you of the adding of this up and subtracting of everything. But the $300,000, okay, this part, it's not going to know. So you need a calculator actually for this part. If the lender requires 3.5% down for this type of loan, times 3.5%, that's $10,500, right? $10,500. Now, if they put down the $1,000 good faith deposit already, how much are they going to need to bring for the second deposit? $9,500, right? If they don't have all that money right now, and some of that money they're going to need to bring to closing later, well, you would then split up however much they're going to make for the second deposit. And over here where it says balance of the purchase price, you're going to write it on this line. So this line where it says balance of the purchase price, you can make a notation for yourself here. Amount of money buyer needs to bring to closing. Not for the closing cost, but the amount of the down payment that they didn't pay here, they're going to have to bring it to closing. Here. And so if you're putting this contract together through the online form system, it'll automatically calculate this number for you. Because all it does is it takes the purchase price and subtracts this amount, these amounts, and this is how much mortgage that the borrower needs to qualify for. So you better make sure that their pre-qualification letter is for at least this amount. And in this case, on this line, you would write 0 for balance of purchase price. Make sure that the buyer's initial, all the buyer's initial here at the bottom.
I have a question. If there was, that's given that they're giving the second amount, but let's say they want to bring the third amount at the balance of the closing. So you would put in the balance of purchase price?
Well, no, if the purchase price is $300,000, they have to put down $10,500.
Right, but let's say they put the first payment was 1,000, the second payment was 4,500.
Okay, so then minus 4,500.
Yeah.
And then they still have a balance of 5,000 they need to bring to closing. So then on this line you would write 5,000.
Okay, and there you'll be right 5,000.
Yeah. So that's what goes on this line is any amount that they did not pay here for the first or second deposits that they'll need to bring to closing still. Okay.
Got it.
And don't forget the initials at the bottom of the page. Mucho importante. Don't want anybody swapping out this first page. They got all the numbers on it, right? So we're not going to go over every little detail here that they're going to have to sign, but in your book, make sure that you write down in the margin over here in the book or up here, just write this contract is for an FHA loan 3.5% minimum down. Or just write this in here, just write this contract is for an FHA loan. You're using an FHA loan.
Where do you write that?
Just write it anywhere here, either in the margin or up here above where the 300,000 is, anywhere in this area or on the margin. Right, this contract is for using an FHA loan or using FHA financing, however you like to use it, word it. Let me know when everybody's done with that. Everybody do that? Everybody wrote this is for an FHA loan? Or this
Yes.
contract is using FHA? Okay. So now at the top of the page, of that same page still first, you got a big empty spot at the top of the page in your book. I want you to write a note for yourself. I want you to write, it's going to be 2 lines. One line you're going to write, VA loans do not require down payment. VA loans, that's Veterans Administration, that's for veterans only. VA loans do not require down payment. Let me know when you got that written down.
Got it.
Yes.
Do you have to be in a specific financial bracket to qualify for that?
Depending on who you're getting a loan from. Your credit score needs to be a minimum of something, and then they qualify you by debt to income ratio. How much money you make versus what your debts are. We'll go over that in the mortgage chapters.
Right, but you have to, is there a minimum or high or like a cap?
Well, every lender has their own lending guidelines. You know,
Oh, okay.
but we call these qualifying ratios. We'll go over that in the mortgage chapter.
Okay.
Right, now, I want you to make another note there at the top of the page underneath that VA one. I want you to write FHA in all capital letters. Requires 3.5% minimum down payment. FHA requires 3.5% minimum down payment required. Okay.
Got it.
All right. So now we know that we already did the math based on FHA loans here down the bottom. All right. Turn the page in the book, which will bring you to section 3 here. In this case, you're the participating broker and the buyer's agent, you're the participating broker, so that initial deposit is paid by the buyer too, and you're going to X participating broker, and then when they gave you that money, all right? And then additional deposit, I don't actually write a date on this line. I can't tell you when the last time is that I wrote a date on this line. Instead, I write this, 10 days after attorney review. When does the second deposit need to be given? Well, we're not going to be holding on to it forever if that attorney review is taken forever. It could be kept in the buyer's savings bank collecting whatever minimal interest they're paying out. And you know, buyers are going to bitch and complain. Oh, do I got to put it in your account? How about when the offer is accepted? You know, whatever. You know, you're arguing over pennies. Keep it in your account. You need to give it to me within 10 days after the conclusion of attorney review. That's what this means. And if we write that there, or if we write a date, we need to be aware of this date. It's our responsibility as a buyer's agent to get that money from the buyer by that date. If we don't, we have to reach out to the other side and let them know we don't have it. Because we got to treat everybody fairly and honestly in a transaction. Can't, if the buyer doesn't have that money for whatever reason, got to let the other parties know. It's unfair to ask them to keep their property off the market when we know that the buyer doesn't have the money to go through with the purchase. All right. And then the escrow, all that money is going to be held in whose bank account? Well, it could be given to an attorney. It could be given to one of the brokers. In this case, it was given to us. So we're going to write here the name of your brokerage, bearing non-interest bearing trust account of, and you're going to write the name of your company's brokerage there, or the name of the attorney's law firm, whoever is going to be holding the money. Okay. Then we go down to section D, line 75. And over here, what's that principal amount that they need to qualify for a loan? So we got, you could get that from the bottom of the first page. $289,500. We're going to write $289,500 there. $289,500. That's the mortgage that they need to qualify for. And then we're going to check off that X. We're going to put an X next to the box for FHA loan. Term of mortgage, 30-year, based on 30-year payment schedule. Boom. And the date in this section. This is when the buyer has to produce the mortgage commitment letter by. All right. That'll be typically 30 to 45 calendar days from date of contract. Ensure that the date that you put there lands on a business day. So what are we going to write? I'm going to say to write just above here on line 77 in this big empty spot, and then put a little arrow down to here because that's where you're going to put the actual date. You put an actual date on this line that's going to be an actual business day. So I wrote as a note up top here, business date, business day, date, 30 calendar days from date of contract. Business day, date, 30 calendar days from date of contract. So from today's date that you're putting the contract together, count 30 days on a calendar. You don't have to count business days, just count calendar days. And make sure that the date that it lands on is a business day. Not a weekend, not a holiday. Make sure you have on your calendar religious holidays too. Okay.
So
Common.
that date is from the date that was signed.
Which is the date that you're preparing this contract.
Okay.
All right. Then, you got all that written down, everybody? Business day, date, 30 calendar days from date of contract. Everybody got that?
Yeah.
All right. So then let's scroll down a little bit here and balance of purchase price. This stuff is pretty self-explanatory. Okay, so here is going to be where we put the closing date. The anticipated closing date should be 45 to 60 days from the date of contract, ending on a business day. So make a note for yourself up here or on here. 45 to 60 days, just put 60 days. 45 days, you're rushing it a little bit. But anywhere between 45 to 60 calendar days from date of contract, you could close. Okay. This is the closing date here. Now, sometimes you're going to have buyers that are either superstitious or they're religious or they have some kind of cultural thing they followed. Maybe they follow feng shui principles or their guru gave them advice on what numbers are lucky for them or what have you. And they're not going to want a certain date because it has a number in it. Listen, whatever. Just go with whatever they mark off there, okay? Or whatever their wishes are. They're the buyer, it's their wishes. It's not likely that they're going to close on that date anyway. The dates usually get shifted and they usually don't complain about it then. But when we're writing it here, all of a sudden it's a big issue, okay? Just make sure that, I mean, we do have closings that do close on the date that we write in the contracts, but more often than not, it's pretty common that we get the closing gets pushed off a day or two because of whatever reasons. The attorney, the closing, the bank, the wiring, something had a little hiccup. It'll usually bounce around a day or two, okay? Make sure they initial the bottom of the page. And this, at the bottom of the page here, it says items included in the sale, which is carried over to the next page. At the end of that section on line 115-ish, 114, 115-ish, okay? You're gonna write per MLS number and then put an MLS number in there, you know, per MLS number, da-da-da-da-da-da. What items are included in the sale? Well, whatever was listed in the MLS. But if there's additional items that may have been listed on the seller property condition disclosure report, write per MLS number, underscore, 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 you actually write the MLS number there. And then you could actually write each individual item that are also going to be included, or you could say per MLS number and seller disclosure report. Property condition disclosure report or whatever, okay? Or if you had a conversation with the listing agent, you know, this is going to be included, but that's not going to be included, right? If something's not going to be included, that's the next section, 7. Items excluded from the sale. It says if reference is made to the MLS sheet or any other document, then the document referred to should be attached to the listing. So make sure that you print out the listing and you attach it to the contract as well. If you're doing this, if you're writing per MLS number, print out the MLS thing and then have it. You know what? These days it's hard for agents to get sneaky because the MLS holds a history of the last couple changes that were made to the MLS. But in the past, this was very important that you print out that document from the MLS sheet. Because I had a situation once before where the agent tried getting sneaky and they changed it. And I noticed when we were going through the attorney review, I'm like, no, this is bullshit. That's included in there. And they're like, no, it's not. Look in the MLS. I was like, I did. I actually attached the MLS printout, which I printed the day that we made the offer. You had since changed it in the MLS. Right? But these days, it doesn't matter. You can see the revisions in history in the MLS. So if an agent does that, they're busted, right? So I also wrote a little note here, which you should write a little note in your book, plus any items the listing agent specifically excluded from the sale. So let's say that you had a verbal conversation with them. They forgot to put it in the MLS or on the seller disclosure that the chandelier is not included. The seller's taken that. So write that info in here that the chandelier is not included. But you should have a conversation with them. Well, are they replacing it with something? Are they leaving a dangling electrical wire there? You know, they should replace it with another fixture, right?
And the same contract, Victor, we will fill out if it's a commercial property or the mobile homes?
Oh, wait a minute. We don't prepare contracts for commercial properties. Who does?
Okay,
The attorney, right?
attorneys, okay,
Right.
yep.
Okay.
And for mobile homes?
Well, for the sale of mobile home, a mobile home is not considered real estate. They use the title from motor vehicle from DMV. The only time that it would have a deed, and we'd actually use the same sales contract for it, is if the axles are removed and it's permanently mounted to a foundation on the land, right?
Yeah, so in that situation, we use the same sales contract.
Same sales contract, correct.
Okay.
All right. And then there's a lot of other stuff here, which I'm not going to go over all the details with you. You guys can read this contract over on your own when you got a magnifying glass handy, because I know in the book it's kind of shrunk down the sizes. And let's see. In here, certificate of occupancy, zoning compliance. This is about the spending. If the money needed for repairs exceeds a certain dollar figure, or if left blank, a percentage of the sales price to do the repairs, then either party can back out of the contract, the seller or the buyer, okay? Municipal assessments, do they owe any money to the municipality, like back taxes or anything like that, special assessment taxes? Have them initial the bottom of every page. You should highlight this so that you don't forget. Okay. Where it says quality and insurability of title. If the property is a one-family house, you better list it as a one-family house. You need to write in this contract, if it's a one-family house, write single family here. Okay. Or you could write one. Either way, it doesn't matter. Two family, you're going to spell out the word two. Three family, three. Four family, four. We don't go beyond that. Anything more than four family is commercial property, and we don't prepare the contract for it. All right. So if it's a two family with the bonus apartment, you better not write three family here. You just admitted to doing something illegal on a contract. Marketing this property, selling it as a three family when it's only illegal two. All right. Tenancy, whether they have tenants or not, then you'd list all the tenants' names and everything. If not, then you're going to write what on these lines or in this whole section. N/A, real big. N/A, repeat it, write it right across this area. N/A for not applicable. You're going to check off over here. Is that property built prior to 1978 or not? And okay, then this whole section is talking about the lead rights, the inspections, if there is lead found, someone's doing work, the proposed work that they're going to do, if the other party's going to accept it or not, how many days back and forth. I just write 3 in here. Point of entry systems. Remember what this is pertaining to? For the water, remember I showed you the video about them POET systems over there in, what was that, Warren County or something like that? Where with the, whatever, the POET systems, the point of entry systems, they're the filtration systems for the water. Does the house have that or not? Cesspools, are they on city sewer or do they have cesspools here on this property? And it gets into questions about that. I'm not going to get deep into that. You guys can read that on your own and go through and answer the questions accordingly. Inspection contingency clauses, relationships to the homeowner. You got to disclose all this crap. Radon for picocuries, that's on exam, right? Insect infestation. Okay. If left blank, if you don't put it on here, it's within 14 days. Okay. This is when you're going to get that inspection done from wood destroying insects. Well, you want to make sure that that's done within, right after attorney review, right? So you could just leave these blank and it'll go by 14, 14, and 7 here then. Or fill them in, put 14, 14, and 7, right? I don't like leaving blank lines. Buyer's rights to inspection, same stuff. Flood insurance, Megan's Law, got all those disclosures that we talked about here, right? We talked about so far. Here's all the airport's flight path safety zone information entered in here. Bulk sales, this deals with if this property was, sometimes the state of New Jersey will withhold some money at closing until they find out whether the appropriate taxes have been paid on somebody. This is that bulk sale. If they're moving out of state. Yada, yada, yada. Okay, here's a section where like you put your brokerage name, like I have mine in here. My brokerage is Jersey Brokers, and here's my company license number. I wrote that in there. In this case, if we're not the listing agency, we're only working with the buyer, then we're working as a buyer's agent only. And then you would put down the other brokerage's name here and check off how they're representing their client, which would be represented in the listing itself. They would check that off. I told you you'd have that one window open where you get the license number and the names and addresses of the brokerage and all that contact information. You could get that from the MLS, as well as, well, the license numbers, you got to get that from the state's page, which was this page. Remember I told you about? You get the license numbers from there, okay? Commissions, you get them from the MLS. Look, they have a checkbox here. If you're buying this real estate, what disclosure that buyer or seller is a real estate licensee. Is it applicable or not applicable to the situation? If so, look at that. So we always used to have to write something in there. Now it's standard written in there for us, and we just check off whether it's applicable or not and fill out the appropriate stuff. So it's not a bad idea for you guys to read these contracts on your own when you get a chance, okay? And here's a bunch of additional addenda that we could add to contracts. But look, there could be many more than this, okay? But if you're adding any of these, here's some common ones, you would check it off. Well, in this one, it's a FHA, so we checked that off. In this one, it was pre-1978, so we checked off that one, okay? In this section, 43, here's where we would write any additional contractual provisions if we wanted to ask the seller to include the washer and dryer. Or check this out. This is a pretty cool one. We could ask for what's known as a seller's concession. Okay, so what is a seller's concession? It's any money that we're asking the seller to concede. What does the word concede mean? How about this? We're going through a presidential election right now. When presidents every time there's an election, and they do the counts, sometimes it's more gracious for one person when you see there's obviously no way the other person could win because they got so many votes. The other party would graciously concede, so that basically they're agreeing to give up. There's no way that I could win this election, obviously, so I'm going to concede. So it basically means give up. So a seller's concession is when a seller gives up, they concede money to the buyer for either repairs, closing costs, or towards their mortgage, okay? Now you may be thinking, why would a seller give money to the buyer for their closing costs? Well, to make the sale happen, silly. I mean, if we're in a market that there's maybe not a whole lot of buyers out there eager to put offers on your property, it's not a bad idea for the seller to consider offering a seller's concession to a buyer. I tell you what, I don't care what market it is, I always ask for a seller's concession to try to save my client some money. I always ask for a seller's concession. Doesn't matter what market it is. You know, they're either going to agree to it or they're not going to agree to it, right? Saying, and this is the way that I would usually word it. You could have your own wordings, or maybe your broker has some stock clauses that are written a standard way. I would always write in there, seller agrees to a buyer's concession. Seller agrees to a concession of up to 3% towards the buyer's closing costs and prepaids. This is a concession and not a loan. All right. I'm basically saying that the seller's agreeing to give the buyer up to 3%, not 3%, but up to. You know, if their closing costs are less than 3%, then the seller gets to keep that remaining balance. But I did say up to 3% towards the buyer's closing costs and prepaids. So that basically means that I don't have to write up to, I could just say 3% towards buyer's closing costs and prepaids. If the closing costs are less than 3%, prepaids is prepaid interest on the buyer's loan. All right. We'll get into that a little bit later when we talk about mortgage stuff, but that's a little sneaky way to write it and stick it in there and get that money and keep it. All right. But we're asking the seller to give us money to help pay for the closing costs so that we can make the deal happen. Because the buyer already needs 3.5% to put down, and typically closing costs are 2 to 3% of the purchase price. Typically, depends on the lender, okay, and the value of the home.
So in terms of that number, right? Whatever that dollar value transaction is going to be as part of that concession, how would that flow through? Would it go to the buyer's bank account through escrow, or will it go to lender?
No, the closing agent, whoever the closing agent is that's handling it, that money comes out of the proceeds from the sale.
Mm-hmm.
And that goes, what are they using it for? Are they using it towards closing costs? Well, if they're using towards closing costs, the buyer never gets it. It goes directly to their lender.
Okay.
What are closing costs used for? What are closing costs used for? Well, we call them impounds. The impounds, this money that we're putting, is basically, it creates a reserve account for the coming year's payment for certain expenses, like the taxes or homeowner's insurance. If those expenses are included in your mortgage payment, they don't have to be. Okay, so that's a huge bit to it. The taxes and insurance, homeowner's insurance, and you know, the lender may have an amount. Maybe they want a month or two of the mortgage payments in impounds.
In advance, yeah.
Victor,
Depends on the lender.
Gotcha.
sorry, I have a question about the taxes.
Yep.
Can you elect to pay your taxes on your own and not
Yes.
add it to the mortgage?
Yes. You do not need to include your homeowner's insurance or your property taxes in your monthly mortgage payment. However, lenders will try to bribe you or entice you. Here, that's a nicer word. They try to entice you into including it with that by in your monthly mortgage payment by offering you an 1/8 of a point discount on your interest rate that you pay. Okay?
I knew the answer to that, but I was trying to explain to someone about the stuff you were explaining to us, so we can buy people's taxes.
Yeah, the tax foreclosure sales. Yeah. So
Yeah.
it does
They
not.
kept telling me that the taxes has to be included, and I'm like, no, for my understanding from what you said,
Absolutely.
I
does
just wanted
not.
clarification.
Absolutely does not. The lender, however, tries to entice you to include it so that they could give you, by giving you a little bit lower interest rate on your loan. So a lot of people these days do include them, but you don't need to. You could pay those bills separately all on your own.
I mean, when you include them, you end up paying more money, right? Because in the end, they're
You end up paying more when you include them in your monthly mortgage payment. You pay a little more money up front at closing because you're prepaying. You're starting to build an account towards next year's tax bill.
right. But is there interest on paying on taxes? No.
I know the The only time there's interest on taxes is when you don't pay them on time. Right?
Okay, but the lender's not charging you for it because they have to
No,
pay it
the
out.
lender pays it to you. Any money that the lender is holding in escrow, they have to pay you interest on that money that they're holding, because you could have been holding that money in your own bank account.
I have another
How are they
question.
paying you?
And what's that?
How they end up paying you then?
It goes towards credited towards your mortgage payments in your accounts, or sometimes they say we have an overage of funds in our escrow account, and then they send a check to you, or any overages over $50 in the escrow account, the lender has to send to you. Sometimes people who have mortgages, you get a letter from the lender about your monthly mortgage payment. Say your taxes went up. You get a letter from the lender that says there's a shortage in your escrow account. You need to pay a higher amount for your mortgage this month to make up for that shortage for next year's income, impounds. And then you pay that. And then a couple months later, they're seeing, oh, wait, it turns out we actually overestimated it. Now we have an overage. So now they're going to end up giving you a refund now, but they have to do that accounting at least once a year. And they have to give the credit, they have to give the money back to that the borrower at least once a year of any overage that's over $50 that they hold in their escrow account, and over $50 more than what they need, any excess. They can't just have excess and have it just be holding onto it because,
I have another question.
Uh-huh.
So when I sold my house, my husband and I sold our house in South Plainfield. We were already through the process. So would this be considered a concession? The city, we had a permit that we needed to close out, but the city was giving us a hard time. So the buyer mortgage was pre-approved, but it was like a 30-day window. If I'm saying that correctly.
For the mortgage lock, for the interest rate lock on the loan or something?
Yeah.
Okay.
So we had to pay. So this would be considered a concession, right? Because we had to pay to extend that another month.
No,
But we kind of had to pay twice because the city was just giving us a headache.
you don't need to pay that. They need to pay it. But if you couldn't get the
Permit.
the certificate of occupancy or fire inspection certificates, right? Those permits that you're talking about, the certificates.
No, it was actually, my husband was like working on the attic and putting in a window in the attic. And while he was there, he decided, okay, I'm just going to put some sheetrock to not keep it cold.
Oh, that was the last minute thing you decided during the transaction?
So when the guy came to inspect the window, he was like, oh, you got to stop the inspection, insulation. And he kind of put a little tag on there. So we had to go back and
anytime you're doing construction with the framing or anything like that, you need permits for the work. He's putting in something new. He's not replacing an existing.
Well, no, we got the permit for the window, but he kind of tried to insulate around the window. It wasn't the entire attic. It was just like around the window to insulate it. And it's South Plainfield. You have your office in South Plainfield. They're sticklers for every little thing. So we ended up having to pay the cost for the young lady to extend her.
Well, the bottom line, what you're saying is whatever it was that was getting done, it was your fault that it went over, that you weren't able to close yet. So therefore, they wanted you to pay for the extension of the rate lock. In essence. Okay. Yeah, I can understand that.
So would that be considered like a...
That would be a seller's concession. You're paying for that. Yeah. Because otherwise you really don't have to, but they're saying, well, it's your fault because it was your responsibility to get this and you're in breach of contract if you don't. So your attorney probably said, just pay it. Right. So, okay. So that's that. We're done with this contract. We're done with this transaction and we're done with this chapter. So go to chapter 12. And I will. Okay, by the way, all those notes that I were giving you on how to fill out this contract, it's on the last 2 slides of chapter 11. That's the ones that you're That's these
Is
ones,
that going to be on an exam?
this one, and this one. No, this helps you fill out all this stuff. I just helped you, guide you. This is stuff your broker should be teaching you about the timelines and all that stuff. We went over everything throughout the rest of the slides, and I just went over the actual how you really do it. You know, conventional loans typically require 20% down payment, but it can be less depending on the lender. FHA loans usually require 3.5%. Well, require minimum 3.5%, but the buyer can put down more money if they wanted to, if they have it. VA loans require no down payment, although some lenders may ask for it, but then they would get refunded the difference when it comes to closing in the end anyway, because the VA doesn't have a requirement like that, but the lender may. The concession, typically concessions for FHA and VA loans, like towards closing costs for repairs and stuff like that, they do have limits on it. The law has limits. If it's an FHA or VA loan, the maximum seller concession allowed 6%, and for conventional loans, the maximum is 3%. Okay? And on that, that's the end of that. That's the end of chapter 11. Let me just save that slideshow and close it out. And I'll update it after class online. Let me open up chapter 12 now. Chapter 12 is about renting, leases, and landlords. This is chapter 12. Yay. It's a long chapter, goes over a lot more terminology. Remember in an earlier chapter, 6 or 7 it was, we went over types of estates and land. What is an estate and land? Do you guys recall what that terminology means, estate and land? It describes the amount and kind of interest that one has in real property. And what is the category of ownership estates called? Freehold. It's a freehold estate. Okay, you're free to hold the property forever or for a lifetime. Unrestricted ownership forever. What do they call that? Fee simple absolute. Ownership forever based on a restriction. What do they call that? Fee determinable or defeasible fee estates. And then we have a life estate, which is a form of ownership. What do we call a life estate based on someone else's life? In Latin, por attravi, for the life of another. Okay, so this chapter now is going to go over the other category of estates, which is less than freehold. You're not free to hold it forever or a lifetime. It is called a leasehold. And so that's what this chapter, we're going to start it off by going over the 4 types of leasehold estates, okay? So at the end of this chapter, you're going to be able to describe, well, we're going over a lot of stuff in this chapter about renting, the laws, and all that stuff, explaining the 4 leasehold estates, standard provisions added into leases and any contract for that matter. We're going to go over the Truth in Lending Act, Americans with Disabilities Act, discuss differences between various types of leases, identify functions of property managers. And so for that, let's get started. What is a lease? What kind of asset or property is a lease? A lease is an intangible asset in that you do not own real estate when you have a lease. A lease is just a contract that defines your rights to occupy someone else's property for a limited time as defined in the lease. So what kind of property is a lease? It's intangible personal asset or personal property, okay? And so I got all that written here pretty much. And you need to know that a lease is not real property. It is personal intangible assets. You need to know. So, first thing here on this page actually though is demise. Demise is a transfer of property by lease. Every lease has a demising clause in it describing what the landlord is renting and that the tenant is taking possession. A demising clause, it says the landlord is to let and the tenant is to take on possession of those premises. All right, so the root word is lease. So therefore the lessor is the one who gives the lease. The lessee is the tenant, the one that's receiving it. Because remember, words that end in OR versus words that end in EE. Words that end in OR is the person who's giving whatever the root word is. In this case, the root word is lease. So the lessor is the owner and the lessee is the tenant. Okay, the owner who gives the lease, the tenant who received it. Now, a lease is both a contract and conveyance. Turn the page. Page 196. Do they go over that here? Well, it'll be somewhere in this chapter. A lease is both a contract and a conveyance. It's a contract and it defines the party's rights and obligations, and it's a conveyance because the owner is actually transferring their property to the tenant. But it's only for a limited time, as defined in the lease. So, statute of frauds on page 196. In that second paragraph, highlight the first sentence, okay? It basically goes over what the statute of fraud says. We learned this in the last chapter with contracts, that if, well, contracts for purchases all have to be in writing of real estate. But leases, they only have to be in writing if they're 3 or more years. If they're 2 or more years, they can be recorded in the public record. Now, if a real estate agent is involved, it always needs to be in writing, okay? This is just stating the law if no agents are involved, because we have to follow real estate licensing law as well. And this is the same slide that we had in the previous chapter I put in there too. It's extremely risky to rely on oral agreements or contracts, right? So this way, real estate licensees, we also follow the Real Estate Commission rules that state that we must have all contracts for sale or lease in writing, and we must never have verbal contracts, all right? Actually, let me check something really quick. Time out, time out, time out. I want to open up the chapter 11 again. I'm just going backtrack for a second. Pertaining to that, this slide, statute of frauds, search. Yeah. Okay, so what I did is, you're going to see right here. Can you guys still see a slideshow or no?
No.
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 All right. There you go. Now you can. All right. So what I did is I just went back to the chapter 11, the slideshow I opened up, because this slide I edited in there and basically made these changes. Poof. There we go. I actually put in the title 4515 and 11.5 next to there. So that's all I want to do. Just make it fancy, more accurate. That's it. All right. Try to be as complete in my data that I provide for you as possible. It's that OCD thing, right? I really don't have OCD, but I just like to be, maybe I do. I don't know, mild case. All right. So the statute of frauds states that all the leases have to be in writing. And if it's a real estate agent that's involved, we always need to have contracts in writing because we got to follow Licensing Law 4515, and the Rex Rules and Regulations, Title 11, Chapter 5. Are you guys still seeing that window minimized, or are you seeing the bigger full screen window now for the slideshow? Okay.
Full screen.
Wow, it's amazing that that goes full screen for you and you guys can still see it, but then when I back out of it and minimize it, you can't see it anymore. I don't know why it does that. That's Zoom. All right, next slide. These are the 4 types of, well, here's describing the leasehold estates like I started out this chapter, explaining to you estates in land, describe the amount and kind of interest that someone has in real property, and there's 2 categories of them. We have freehold estates, which there's 3 types that they describe the ownership, and I already went over them with you. The fee simple absolute's 1, fee determinable, the feasible fee is the other, and life estate or life estate per autrui is the 3rd. Now, the leasehold estates or less than freehold, they're not ownership. An owner intentionally transfers some of their interest in the real estate that they own to the tenant for a limited period of time as defined in the lease. So a lease is considered both considered personal property that is an intangible or incorporeal assets. And these are the 4 types of freehold estates that you see here in the book. Highlight the title, Leasehold Estates, and write the number 4 in front of it. These are the 4 types of leasehold estates you must know. You must know the 3 types of freehold. You must study the 3 types of freehold estates, the 4 types of leasehold estates. I hope you guys aren't waiting to cram at the end, but whatever. It's up to you. We're not giving the exam on the last day. We're allowing you to take it whenever, within 6 months, of course. So, we're going to start off. These are the 4 types of leasehold estates. We're going to highlight them all in this list. Estate for years, periodic estate, tenancy at will, and tenancy at sufferance. And now we're going to go over each individual one in detail. Now, rent is still due at specific intervals per the lease, no matter which one of these leasehold estates you have. Anyone who terminates a lease early, they're basically in breach of contract. What does that mean? If you're in breach, anybody? Means that you broke the contract.
Breaking the contract.
You broke the contract without a good legal excuse to do so. So anybody who terminates a lease early is in breach of contract. However, could you terminate a lease early with the landlord's permission? You both
Yes.
agree to it? Yeah,
Yes.
you can.
Yes.
You can both agree to it. And there's a way to get out of a lease. Don't just break it. Talk to the landlord. Maybe they'll work with you, right? Just don't be a jerk to them and have the conversation, and maybe they won't be a jerk to you. Maybe. All right. So a holdover tenant, here's some terminology we need to know that's going to be coming up. So we're going over it now in advance. A holdover tenant, we call a holdover tenant is anyone who did not vacate the premises after their leasehold rights had expired. So their lease expired and they didn't move out. They've held possession of the premises and they did not move out. So the landlord has 2 options at this point. They can either accept the holdover tenancy or they could choose to evict them. It would all depend. Is the tenant still paying rent or not? You know, that's what it would depend on, right? But then again, the landlord could be like, well, I don't care if you're paying rent. If you don't sign the lease with me, I don't want you there, right? So a tenant may try to be like, well, you know what? I don't want to sign a new lease. I just want to continue paying the rent, see if I can get away with that because I may want to leave early. And the landlord will be like, no, I don't want you living here if you're not paying the rent. See, if the landlord accepts a rent payment from you and you didn't sign a new lease and they accept the rent payment, well, in the eyes of the law, the landlord just said that they're okay with you becoming month to month. All right. So this is why a landlord, if they don't want you in there, they should not cash that check. Because if they cash the check, in the eyes of the law, they're okay with you being month-to-month tenant. They should hold on to the check and file for the eviction, and then ask the court if it's okay to cash the check because you were still living there. Now, the landlord could also ask if the court would award them an additional month rent. Go ahead, ask why.
Why?
Because you told the landlord that you were going to move out and you didn't move out. Every month that the tenant holds over, if they told the landlord that they were not staying, that they were going to move out, the law actually entitles them to double the rent every time for every month that that tenant is there that held over. Why? Well, maybe that landlord already lined up another tenant to move in when you moved out, but you never moved out. So now the landlord's in breach of contract with the new tenant, and they got to put the new tenant up somewhere too. So you're actually even costing the landlord money now. Good enough reason?
Yeah.
Okay. A lot of tenants don't look at it like that. They don't care about it. They just look at that, well, I need a place to be, you know. They don't look at it from the landlord's. You always got to look at things. I don't care what it is in life. You always got to look at things from the perspective of the other party involved in the whatever it is that we're talking about. Okay. So eviction, the term eviction, we're going to learn about too. Eviction is a legal process of removing the tenant who's temporarily occupying your property. Okay. It's not foreclosure. Right? Foreclosure is a legal process by which which somebody who has a financial interest in a property seeks to sell a property or gain ownership of it so that they can recoup their money through the sale of the assets that may be collateral for that loan. All right. Now, a leasehold estate, we're going to go over these one at a time here. Let's start off with leasehold estates. Now, on page 196, you have figure 12.1 over here that shows you the 4 types of leasehold estates and what their distinguishing characteristics are. Next to an estate for years, it shows it's a lease for a definite period of time. You could, I would make a little notation next to that. Fixed period with an end date. It's for a fixed period of time with a definite end date in the lease. Would be an estate for years. The estate from period to period, also known as a periodic estate, its distinguishing characteristic is that it automatically renews. So I would just write has a renewal date in it next to that. Then an estate at will, it's for an indefinite period of time. Highlight indefinite period of time right there. And then an estate at sufferance is without the landlord's consent. Okay, we're going to go over all these in a little more detail. I don't want to give the cat out of the bag yet for all these. So for the estate for years, let's highlight the title, Estate for Years, in the book. And highlight a leasehold estate. Then go to the end of the line. With a specific termination date in it is a leasehold, is an estate for years. All right. Skip the next line and the following line at the end we're going to highlight. No notice is required to terminate such a lease at the end of the term. Then, next paragraph, we're going to highlight an estate for years need not necessarily last for years. Stop right there. Then, highlight its distinguishing characteristic is that it begins and ends at a specific time. All right, so let's look at the slide I have here. It pretty much says the same thing. An estate for years. Don't let that name fool you. Don't let it trick you. It doesn't need to be for a term of years. The distinguishing characteristics is that it's for a fixed period of time, has a start date and an end date. You know when the lease term is going to end. That's an estate for years. If it has an end date, or if it's for a fixed term, it could be 1 week, 3 months, 6 months, a year, 2 years, 3 years. If you know when it's going to end, it's an estate for years. But it doesn't have to even be for a year. It could be for 3 months. So don't let the name fool you in thinking that it has to be for years, a period for years, okay? So it's for a specific defined period of time with an end date. No notice to quit is required to terminate at the end of the lease term. Why? Let's look at the next bullet point. Because it has an expiration date in the lease. If the tenant doesn't renew it, they must vacate at the end of the term. So the landlord doesn't have to give you any further notice to vacate. If you didn't renew the lease, you got to go. Now, a periodic estate, also known as an estate from period to period. So let's highlight a periodic estate, sometimes called an estate from period to period, are created when a landlord and tenant enter into an agreement that continues for an indefinite length of time without a specific expiration date. And then let's highlight the last sentence in that same paragraph. The agreement is automatically renewed for similar succeeding periods until one of the parties gives notice to terminate. All right, so on page 197, in the third paragraph, it says to terminate a periodic estate, either the landlord or the tenant must give proper notice. To end a month-to-month tenancy, New Jersey requires 1 month's written notice before the date of the rent is due. Local rent control regulations may set a different requirement. All right, but either way, proper notice must be given. This slide over here, which is going to be shown on a different page, I like to keep the stuff together to study from. So I have it all here in this slide right now that you're looking at. A periodic estate, also known as an estate from period to period. It's a lease that does have a date in it, but that date is a renewal date, not an end date. If the tenant does not give the landlord notice to quit, meaning that they're not going to renew the lease, then it will automatically renew for the same amount of time that the lease was originally written for. If it's 3 months, it'll automatically renew for 3 more months. If it's month to month, if it's a month, it'll automatically renew for another month. If it's a year, it'll automatically renew for another year, so on and so forth, okay? So the lease will automatically renew for the same amount of time the original lease was written for. Either party may give notice to quit, terminate. How much notice to terminate depends on the term of the lease. So now we got this little guide that I put here to keep all your notes together because it's on a different page for this in the book. Notice to quit required is for a week-to-week tenancy it's 1 month's notice before the rent is due. Before the rent is due. Month to month, 1 month's notice. If it's for a period of years, then 3 months notice is required to terminate. Okay, so we got to just basically know the basics of this, that it's automatically renewed unless one of the parties gives notice to quit, and we need to know the periods of how much notice needs to be given. Week to week, 1 week, month to month, 1 month. If it's a period of years, 3 months notice. Now, I have this note down here that says when a tenant gives their notice to quit and they don't vacate, but then doesn't vacate, they can be held liable for double the rent. Okay? Little factoid, but not needed for exam. Now, go to tenancy at will. An estate or tenancy at will is for a definite period of time. There's, an indefinite. It's not defined. An indefinite means no length of time was specified or defined in the lease. It's an indefinite, undefined period of time. Either party must give 3 months notice to terminate. Termination will be done automatically by the death of either the landlord or the tenant. Both parties must agree to the indefinite term with 3 months notice to quit required. So an example of when this would be used, I mean, anybody can use it, but here's an example where it's commonly used. If a landlord was notified that the state was taking their property by eminent domain and doesn't know how long they can lease it out for. So they can't specify a lease term in the lease. So they tell the tenant, listen, you could stay here as long as you like, but at some point the state's going to take my property. I will give you 3 months notice when you got to go. But you got to be out in 3 months. So both parties have to agree to this. If they agree to it, then both. There you go. A tenancy at will. At the landlord's will. Actually, at either party's will. Either party needs to give 3 months notice to terminate tenancy at will. So in the book, let's do our highlighting. Highlight the first sentence under tenancy at will. That says an estate gives the tenant the right to possess with the consent of the landlord for an indefinite period is a tenancy at will. Rent is due at regular intervals. That applies to all these types of leases, right? Or leasehold estates. These aren't leases, these are the estates. In the second paragraph, next to last sentence, I want you to highlight the term of an estate at will is indefinite, but the estate must be terminated by giving 3 months notice. And then lastly, we have a tenancy at sufferance or estate at sufferance. This is when a tenant had a valid, lawful lease at some point in time. This is not for squatters. This is a tenant who had a valid legal lease. The lease term had expired and they didn't renew a lease. They told the landlord they were moving out and they didn't. And they're not paying rent. So every month that they stay there, they cause the landlord to suffer. Thus, a tenancy at sufferance. Who's suffering? The landlord is suffering because you got a tenant there that didn't move out and they're not paying rent. This tenant can be evicted at any time. No notice is needed to give to a tenant at sufferance. First of all, they don't have a valid lease. Second of all, they're not paying rent. So even if they did have a valid lease, no notice needs to be given. You could evict a tenant at any time if they're not paying rent. You don't have to give them any notice whatsoever. You just take them to court. Eviction is a court process. Remember that. Let's back that up. Look at the bottom of this. Look at the bottom of this page here. Eviction is a legal process of removing a tenant. You know what? I'm going to say through the court system, through the courts. All right. Oh, you guys probably can't see the changes that I'm making right now, can you? All right, well, I went back and I made a change to one of the slides. And once I save it and go full screen. Oh, you can see it?
Yes.
Oh, okay.
Yeah.
Oh, look at that. Okay, so if I put you on the small screen, even though it goes big screen, even if I back out of it, then you could still see it. That's good. Okay, good to know.
Yes.
Okay. Because it gives me two windows, one in edit mode and one in big screen mode. If I share the big screen mode with you, if I get out of it, you can't see it anymore. But the small screen you can. Okay, good to know. All right, so you see what I did down here at the bottom? I made a little change to what eviction is. I
Yes.
further defined it. It said it's a legal process of removing a tenant. That's all I had there before. And then I added through the court system. A landlord cannot lock a tenant out or turn off services or physically remove them, okay? A tenant has rights still, even if they're not paying rent, okay? So you have to go through the court system to remove them.
But it's not a easy way to take the tenants out, just to, like, for example, give you some money to move out instead of to go to court.
Sure. Yeah, whatever to get them out. Yeah, that's fine. Unless it's if it is a foreclosed property and the bank wants you as a real estate agent to offer them money to get out, we call that cash for keys. Do not do it.
Oh,
Do not engage in that. Okay, because
what happened?
if that tenant has a valid lease and you're offering money to get them to get out, you're trying to you're interfering with their rights. They have rights to be there, and it's kind of like you're intimidating them.
Oh, okay.
Don't engage in that. Your question was if you're the landlord and it's your property and the tenant doesn't have a lease there, they didn't get out or whatever, can you offer them some money just to get it the hell out of your own place? Because it may be better to get them out now before doing damages and going through the courts and taking forever to get them out. Give them some money to leave. It may be wise actually to do that. It'll cost you less money. I mean, you're going to be losing money one way or another. It may cost you less money to get them out this way, you know,
Okay.
because unfortunately you can't take a baseball bat in there to get rid of them. Right? You can't get your cousin Vito to go in there and break some heads, right? Can't do that.
You say when there's a foreclosure, right? You cannot do that. They
No, when there's a foreclosure, real estate agents, sometimes banks have gone to real estate agents in the past, asking them to get whoever's in there out of there. If that tenant had a valid lease that's in there, leases survive foreclosure. That tenant still has rights to be in there. So even though the property is bank owned now, that tenant has a legal right to be there. The bank just became a landlord. They don't like that. So they try to get us to go in there. Well, look, let's take a look at the Real Estate Commission's website for a second. I'm going to pull that up. And let me share with you the Commission's website. Let's see on their front page of the Real Estate Commission's website here. Let's scroll down. They have messages here. Yeah, it's something about cash for keys or something like that. Prohibited actions, deposit. Let's continue education. Let's see, cash. Cash. Am I not on the front page? I am. Well, the notice used to be right here, right on the front page. Let's see, other important information. Lockbox, sales leases, permissible actions, property auctions, complaints, printing, downloading estate. Okay, they don't have it listed here, but it is somewhere in their page. It was listed there before. Now remember this? I told you about this. Like this is an exam question, right? Who's exempt from CE requirements? Referral agents and those brokers or broker salespersons with 40 years or more experience, according to this code here. I'm gonna copy that code to that slideshow later on. All right. Enforcement activity, links to related sites, community qualifying, online licensee services, statutes. Okay, it'll probably be in the statutes now, but either way, they always had a notice here pertaining to banks and offering cash for keys. Let me just check, do a Google search. We want to look at the Real Estate Commission websites, not these ones. Truth in Rent. Actually, it's part of the Truth in Renting Act too. Keys and foreclosure. I know I have it in my emails or somewhere. I had a note pertaining to that. Everything you want to know about buying a home, who's made from home buyer. This is from the Department of Banking and Insurance. Let's see if I could search this document. Cash for keys. No.
A question. So if I own, if I'm renting a home and I become a real estate,
yeah.
So how can I approach with this cash for keys, like a landlord? Or I can do that?
Well, wait. What's the question here? If you're
okay, for example, if I own a home, right? I'm renting a home, and then I became a realtor.
Okay.
So when approach to these guys to cash for key, should I do like a landlord, like a owner?
You have to, if you buy a house and it has a tenant in there, you have to honor that lease. Okay. That's why it's a good idea to buy rental properties when they're vacant, or to do your background checks on those tenants first, and to confirm that they've been paying their rent. Because what's to say that the seller's not selling this house because they got a bunch of shitty tenants who aren't paying their rent?
Right.
You know, then you're stuck now. You just bought a property with a headache. You got to get rid of crappy tenants that aren't paying.
So when you do that, so before the closing, you should put a note or something that you want the property without tenants?
You make that as no, not before closing, way before that. You put it in your offer to purchase.
Okay.
That the property needs to be delivered vacant. But the thing is, the landlord may not be able to do that.
Oh.
If those tenants are month to month, they may be able to. If those tenants have a long-term lease, though,
You gotta wait till like the end.
You gotta wait till the end.
Wow.
You know, the only exception to that is if the buyer intends to occupy the unit that that tenant is renting. Then they can be given a notice to vacate.
Okay.
Okay, that's a little exception in the law there. If you're buying the
To
property
be primary resident.
and you want you want to live in that unit that that tenant is currently renting. You know, for
Okay.
instance, I don't want to be on the second floor. That tenant's on the first floor. I want to be on the first floor. I don't want to go up and down the stairs all the time. I want to rent the second floor out. You know, I got issues. I don't want to climb the stairs all the time, or whatever. I don't want to be on the second floor. I want to be on the first floor. So you want that tenant out, you could get that tenant out.
Okay.
But you can't be occupying both units, right? You can't be
Right.
like, well, I want all the tenants out because I'm going to be occupying both. No, you're not. You know, it has to be legitimate, right? Tenants have rights.
So now, quick question: if I bought a home, right, with the tenants in there, and if you want to rent, raise the rent, so you gotta wait till at the end of the lease.
Yeah, wait till the end of the lease and get them out. The only
Oh.
time that you could evict the tenant early is if for non-payment of rent or other violations of the lease. If they're violating the terms of the lease that they have.
Okay.
Okay.
Yep.
If they're month-to-month tenant, what do you got to do if you want them out? Give them notice before the rent is due that you're not renewing the lease. That's only 1 month long anyway. And then how much notice you need to give a tenant that's month-to-month to get out?
Month.
1 month's notice. Correct. So, under tenancy at sufferance, I want you to highlight, tenancy at sufferance arises when a tenant who lawfully came into possession of real property continues after their rights have expired to hold possession of the premises without the consent of the landlord. A tenant at sufferance may be evicted at any time. And I want you, let me see. I want you to write something above that. They screwed up in this definition. They're also not paying rent. You only have a tenancy at sufferance if the tenant's not paying rent. So right there, next to tenancy at sufferance, also not paying rent. That's another book manufacturer screw up that I'm going to add here. Page 197. 197. All right. Here we go. Look at this. Where the hell's the book manufacturer's editor? Well, maybe I guess they're not up on the real estate laws because the person who's writing this book should be up on that. Anyway, leasehold estates. I'm gonna look. Oh, no, nope. I got these things out of order. Let me put these things in proper order. Standard provisions of a lease should be first. All right. So here's some of the standard provisions of in a lease. Now we're in line with the book here. The parties have to have capacity to the contract. There's competent parties. This is just like the essential elements of a valid contract, right? There has to be a demising clause in a lease where the landlord is to let the premises. Landlord lets the premises. The landlord is to let the premises. and the lessee takes possession and the tenant takes possession. Okay. There has to be a description of the premises, what exactly is being rented, and what the tenant can and cannot use. If you don't specify in the lease what the tenant is renting, let's say if it's a one-family house, then they could use the basement, they could use the attic, they could use the garage, unless you specify in the lease, oh, no, garage isn't included. That's where I got my car, and that's where I got my tools. That's where, you only have half the basement. The other half, I got stuff stored down there. If I have a washer and dryer in the basement, you can't use mine. You got to bring your own. If that's the case, you better state that in the lease. That needs to be stated. Those things need to be stated in the lease. It's our job to do that for the tenants, for our landlords, if we got the listing, right? The term must be clearly stated, the duration. How long is the rental for? Is it a year? Is it a month? Is it 6 months? Is it, does it have an expiration date or a renewal date? Is it a, periodic estate or an estate for years? What is it? What kind of deal have we got here? Specifics of the rent and how it's to be paid. Here's a neat little factoid. If it's not stated in the lease, New Jersey law says that the rent is due in the arrears. That means after the end of a period, at the end of the month. So if you have a lease and it doesn't say that rent is due on the first of the month, New Jersey law actually requires that rent is not due until the end of the term at the end of the month, the last day of the month, as opposed to the beginning. That's what arrears are. Where's your rear? In behind, in the back, right? So arrear is at the end. That's your rear end, right? At the end of a period. Now, leases must be in writing if for a term of more than 3 years, and they can be recorded if more than 2. We kind of beat that as a dead horse a bit there, huh? Think it may be on exam. Signatures, any valid lease has to be signed. It is a contract, and it needs to be signed by all the parties involved to the contract. Turn the page. Here's a lease, a sample lease that they give. I'm not going to go over this lease with you. You guys can look at it on your own. It's pretty self-explanatory. Oh, one thing I will go over in this lease. Yeah, I got a couple things out of order here. Hold on. Lease estates recap. Okay, so standard provisions of the lease. Okay, here's the recap of all the lease information now. Every lease has a demising clause. That's what transfers the property, right? Not to be confused with devise. What is devise?
It's the one with
Giving
the
someone property, naming someone in your will.
Devise is a transfer of property by will upon death. Demise is a transfer of property by lease. Leasehold estates are the tenant's rights to occupy someone else's land, and they're considered personal intangible assets, personal property and an intangible asset. It's good. This is a good slide to study from, actually. Got everything compressed. A holdover tenant is a tenant whose right to occupy real estate expired, but they did not vacate at the end of the lease term. Now, the landlord can keep them, or they could choose to evict them. Here's the 4 leasehold estates again, the recap, and everything specific about them in one place. An estate for years is for a specific period of time with a definite termination date. Does not have to be for a period of years, can be month to month or week to week. No notice to terminate at the end of the lease term because it has an expiration date in it. A periodic estate, also known as period to period, is with no specific termination date because it has a renewal date in it. It is perpetual, and it can be for similar succeeding periods like week to week, month to month, or year to year, with no specified end date until one of the parties gives notice to terminate. And that would vary depending on the length of the lease term. What is it how much notice needs to be given for month to month?
Multiple.
1 month.
Week to week, 1 week. And year to year,
3 months.
3 months. All right. I wasn't able to fit all that in the slide, so it looks like I skipped that right here in this one. Tenancy at will is for an indefinite period of time, no termination date, with the consent of the landlord or by court order. And it can be terminated by the death of either the landlord or tenant and requires 3 months notice to terminate. And lastly, a tenancy at sufferance is a tenant who lawfully came into possession, then remains in the property without the consent of their owner. This is not squatter's rights. This isn't somebody who just takes up residency in your house. The tenant can be evicted at any time, such as when a tenant leases expire, then they refuse to leave and the landlord wants them out. The tenant will be called a holdover tenant. Their rights had expired. All right. So here are some of the typical provisions in a lease. The use of the premises, the terms of the lease, start and end date has to be specified. New Jersey, we have to put in the lease the business relationships that the firm has with respect to the parties named in the document. Page 203, section 39. We'll even give a page, a line number. Let me see. Section 39 is line number 318 to 326. 318 to 326. How about that? I'll put that in there. Okay, section 39, line number 318 to 326. All right, so and there has to be an acknowledgement of the CIS because we give them to renters as well, right? Landlord, buyers, sellers, renters, landlords, right? Before you even discuss their motivation. However, if the rental, the lease is less than 125 days, it's not required to be given. But I suggest that you give it to anyone you intend to do business with. This is the disclosure of agency relationships that were found in chapter 3, back on page 43 and 44. Now, New Jersey has a requirement for window guards, and this book does not have any statement pertaining to window guards in it. However, on this same page, on 203, they do talk about window guards. So on line number, what is it, line 292? Yep, I got that stuff right here. Okay, so everything on the slide here. So we will get exam questions on this stuff on state exam. I'm gonna add a question about this on the school exam too. I know it's on state. Window guards. So we need to study this, even though there's no paragraphs in the book, but in the actual contract here on page 203, section 36 pertaining to window guards, I want you to highlight the title that says window guard notifications. And then you're going to highlight on the second line, if a child or children, this is what you're highlighting, if a child or children 10 years of age or younger is or will be living in the apartment or is or will be regularly present there for a substantial period of time, if the tenant gives the owner, the landlord, a written request that the window guards be installed, the owner by the owner or landlord. Then go down to line 303 and highlights window guards are only required to be provided in first floor windows where the window sill is more than 6 feet above grade. All right, so now we got this slide over here for us too that says window guards prevent windows from opening wide enough so that a child could fall out possibly, okay? It must be installed by the landlord. If the child is 10 years of age or younger or will be living there or regularly present, if the tenant gives the landlord a written request to install those window guards. The HOAs, if it's in a condominium or a co-op, they're responsible for the common areas, so they would be responsible for any window guards in the in those common areas like hallways. They're only required on first floor units if the windowsill is at least 6 feet above grade, or if there's some other hazard that would make it dangerous. Okay. Now, how come it's not required on second, third, fourth, 15th story windows? Well, they should have fire escapes. What if there is a fire? If you put window guards on it, the people aren't going to be able to open the window to get out. You're essentially locking them in. Okay? So they only require it on a first floor unit if the window sill is at least 6 feet above grade, because if they do open the window far enough and they fall out, well, they're going to get hurt. I know. The higher up, well, they could die. Yeah, I know. But you could die too if there's a fire. You're locked in there. Okay. Now, buildings with 3+ units, here's an additional rule. You don't need to know, you don't need to study this. This is just additional information that I researched and got. Landlords must install window guards unless the tenant indicates in writing that they do not want them every year before February 15th. They must have the tenant fill out a form about window guards, whether they want them or not. Inspections. The landlord's responsible, they're required every year to inspect them. Installed window guards must be inspected between March 1st and May 1st, and again between September 1st and December 1st. A log, and they need to keep a log recording the results of the inspections. Okay. Now these are for buildings with 3 or more units. The landlord needs to keep these records about window guards.
I have a question. So you're renting a home. Do they still need those guards?
What do you mean by home?
You're renting a home, residential family home.
A one-family house, you're saying?
Yeah.
If the first story unit is more than 6 feet above grade, the first floor window is more than 6 feet above, 6 or more feet above grade, and the tenant requests it. And if they have children 10 years of age or younger that are living there or regularly present there, then yes.
Is 6 feet above grade. So from the floor down?
The ground outside.
On the ground.
On the ground. It's because if they fall outside, what are they falling on?
Yeah.
If there's some kind of hazard out there, or if it's, it's 6 feet above grade, it's a big fall.
6 feet above. So how much does it have to be off the floor?
Off of the ground. It doesn't go by the floor. It goes off of the ground outside.
It has to be.
If it's 6 feet or more above the ground, the windowsill, the bottom of the windowsill.
Okay, you start counting from that.
Yep. Well, if the
But what if the window is like 3 feet?
From the ground?
Yeah.
Then you don't need them.
You don't need them.
It's only if it's 6 feet or more.
Mm-hmm.
Okay. Which is possible. I saw hold on, it's possible.
Counted 6 feet from the bottom, your feet all the way up.
From the floor,
Floor,
from the outside ground, you're counting.
outside ground.
From the
Oh,
outside, from the outside ground, because we're judging the fall. If that child falls outside the window, they're not falling in, they're not climbing in the
I
house.
see.
They can
Okay,
fall outside.
outside.
So if
Okay,
they fall outside, you know, we want to make sure if that fall is 6 feet or more, you know, they could get hurt. So we want to make sure that if it's 6 feet or more, that that window is not going to open so far that they can escape. I'm going to show you some examples of window guards in a minute.
okay, thanks.
Okay. Now, now if they have window AC units there, do they need window guards?
What about like they have screens?
Well, here, if they have, no, it doesn't matter if they got a screen. You need that. You could still install that window guard that prevents the window from opening. You could push through a screen, you know. So window AC units must use tamper-resistant one-way screws to bolt the AC unit in. This way, nobody can take it out. And now they take it out, the window can open all the way as well. Then you got problems. Now, what about on the side? What if that air conditioning unit doesn't fill the full window? Well, any gap of 4.5 inches or more cannot be open. It has to be framed out. Okay. Now, the costs, residents may charge, the cost, residents may be charged up to $20 for each window guard requested. Now, I know that applies to the 3+ units. I couldn't find whether that applies to less than that, even though they require the window guards. I don't know if they could pass on any expense in less than 3-unit buildings or not. But either way, window guards are cheap. You know, you could get some, you could buy windows these days. They have built-in little, those plastic tabs that pull out that prevent the window from opening. That is kind of a window guard, but the problem with it is it can be broken off if you force it enough, or if they're plastic, you know. Here, let me give you some examples of window guards. Here's a picture, okay? Here's some pictures of them. You see this one on the external of the building here? So this is window guards. They're like these bars. You put them up, you bolt them in. So even if the window's open all the way, so the tenant has access to open their window all the way, but you're not gonna have a child falling out of it. There's no gaps big enough for them to fall out of. And to make sure that they weren't tampered with, or the frame is rotting and they're getting loose, landlord has to check them twice a year. Here's another type of window guard right here. For the windows that swing out, it's kind of like an L-shaped bracket. You see in the upper left-hand corner over here, you can get a better picture of it, okay? They put an L-shaped bracket on the outside there that would prevent that window from swinging too far open so that a child can fall through. Or they could use these L-shaped brackets here. You could screw them in with one-way screws into the frame so that the tenant can't move them, open the window more than a certain amount beyond what the window guard is. Because the window guard doesn't allow you, they don't want you to open that window more than 4.5 inches of space. I guess a child can squeeze, small child anyway, can squeeze through that. I don't know. But look, they don't have to be ugly. I mean, they look like this one on the outside of that brick building, but look at this one. This is probably a residential house here, single family house. Okay, this one's white. It matches the white framing. It's not necessarily even noticeable if you're really looking for it, right? From the outside, I guess it looks like bars on the window. But on the inside, I guess it don't look so bad, right? All right. So here's the typical lease provisions. Turn the page, turn the page. On page 206. Just like with contracts for sale, you got to have that lead paint addendum in it, right? And here's a link to the pamphlet, the EPA pamphlet. I don't think I had that in the other chapter, but I got a link to it here. I know it's in the Word document for our links document, class links, but here's the a link to the lead paint disclosure pamphlet that you got to give. You also got to give that signed lead disclosure statement that must first be filled out by the owner and then the tenant. Example of that one is on page 138. And then I showed you an example that we usually use that looks a little bit different than the one in the book. Let's see, lead paint disclosure. So here's a sample of that other lead paint disclosure that we use from the New Jersey Realtors. It looks a little bit different, okay? And it has some additional information in there. You know, has some statements in there. Prior to accepting any purchase, these records were supplied. The seller signs off, their agent signs off, but the seller also has to sign off on this. If there's any changes in the information prior to seller accepting an offer from the purchaser, seller will disclose all changes to the purchaser prior to accepting the offer. Okay. They actually changed that. It used to say anytime during the real estate transaction. So over the years, I guess they changed some of these wordings in here. Anyway, that's that. So, and I got to give that 10-day opportunity for the conducted inspection, or waive the opportunity if they want to close on that rental any sooner. Security deposits. Well, I don't talk about attorney review here, even though it's here in the book. We discussed it in just the last chapter. So just put a highlight, I'll just highlight the title, attorney review, and put a highlighted box around those 3 steps, 1, 2, 3. Okay. For the study, the counting of time and all that stuff, attorney review has to be done or has to be offered. So what needs to be the cover page of any lease that we prepare? What needs to be the cover page of any sales contract that we prepare?
Opinion
The Opinion 26 notice that explains people have the right to hire an attorney, right? And have the review. So what's any different with a lease? There isn't anything. They can use it, they have the right to have an attorney. And if they're not using an attorney, we still have to give them the notice that they have a right to hire one if they should so desire. We got to inform them of their rights. Remember, for any contract prepared by licensees. All right. Security deposits on the next page, 207. I like the title, security deposits. We're going to go over this slide and then we'll go over the highlights, okay? So security deposits for residential real estate anyway. What's the purpose of security deposits? It's a guarantee that the rent will be paid and for damages. It must be placed in a special interest-bearing bank account used only for a tenant's security deposits. The tenants must be notified where that money is being held, and the tenant must get their interest that's earned. It has to be in an interest-bearing bank account, and the tenant must be paid that. The landlord cannot keep that interest. So the landlord has to give the tenant the interest or a credit against their rent for the interest on an annual basis. It has to be credited to them. All right. You know what happens if the landlord doesn't? If the tenant knows their rights, they could take the landlord to court, and the landlord could be compelled to pay the tenant double the entire amount of the security deposit that they've been holding, just for not paying the couple dollars of interest. If you're a landlord, you better know this one. And if you haven't been doing it, it's not too late to get things in order. Get it straight now. Right? So The maximum security deposit allowed by law is 1.5 monthly rental figure. That's the maximum that we're allowed to charge by law. Can a landlord charge pet security? Yes, they can. If it does not exceed the 1.5 times monthly rental figure. If you already got a 1.5 months rent as security deposit, then no, you cannot charge any additional security because that would exceed the maximum allowed by law. But if the landlord was only charging 1 month's rent as security deposit, you can charge up to an additional 0.5 month's rent. Okay, it's just you can't exceed that 1.5 times monthly rental figure. Got it? Now, if you are a landlord and you are going to allow pets, instead of charging an additional security deposit for the pet, how about you charge additional rent for the pet? Or a one-time non-refundable fee? Or both? Provided that it's not a service animal. Because remember, you cannot charge any extra charges for service animals. They're not pets. So, security deposits must be returned within 30 days of lease termination if there are no damages. And the penalty for this violation, once again, double the entire security deposit. What if the tenant moved out and they didn't tell you where they were moving? What do you do with the security deposit? The landlord get to keep it?
Send it to the last known address.
Yes, you send it to the last known address. Because what if that tenant forwarded their mail and didn't tell you about it? Okay, so send it certified mail. So this way you got proof. Certified mail or signature required, what have you, to the last known address. Okay. If it comes back undeliverable because nobody's there to sign it, what have you, the tenant didn't leave any forwarding address, then it will come back to the landlord. Then the landlord just simply does not open that mail. They keep it in their records. And then if the tenant doesn't call back to make a claim against it, what can they do? Can they get to keep it?
They will send it to state.
They got
Send it to the treasury so they could be listed on their website.
That's right. That's right. That's right. Did we already discuss that, or are you guys just that smart?
You told us, well, we didn't discuss the money thing, but you told us about the website.
Yep. So they got to send it. They got to send it to the state. Okay. But a landlord can file with the courts to go to landlord-tenant court and request it from the judge if they want to keep that money for some reason. Maybe they didn't pay the last month's rent or something like that. Unless they had a provision written in the lease for that, even though you're not supposed to do that. Because security deposits are only for damages, okay? But sometimes they could be used as a guarantee of rental payment. In the event that they don't, the landlord can make a claim against it. All right, now, deductions for damages must be itemized. The landlord can't just keep money from the security deposit. They have to give an itemized list of the damages and how much they charge them for fixing this item, how much they charge for fixing that item. It has to be an itemized breakdown list. And the landlord has to do their best to try to save the tenant money. Just like if the tenant was going to do repairs and bill the landlord for it, the tenant has to do their best to try to save the landlord money. All right. Now, if the property's sold, the landlord has to turn over any security deposits to the new owner and notify the tenant that there is a new owner, who they are, contact info, and where their money is. Because that landlord, that new owner, is going to have to turn it over to the tenant have to return it to the tenant if there were no damages. And if they never got that security deposit, so that's an issue, and that's why we have it in the sales contract. Are there any tenants? How much security deposit is there? We need to have that info. pertaining to service animals. We already went over this in chapter 4 with discrimination, I think it was, or chapter 3, one of those chapters we went over it. Service animals are not considered pets, so pet security can be charged as long as the total security deposit does not exceed 1.5 times the monthly rent. However, they cannot charge rent for service animals. They cannot charge additional fees for a service animal which are not pets. Okay, they can charge pet security, well, security, but not pet security. Okay. So how do fair housing laws apply to real life situations? Here's a little thing. I got this from the one of the HUD websites, I think. Here's a situation they give. They say, here's a real life situation. John's been diagnosed with a severe depression and he's disabled as defined by the Fair Housing Act. His doctor prescribes John a dog to help alleviate some of his symptoms. John asks his landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but tells John he'll need to pay a $250 pet deposit and must provide proof that the animal's trained. Did John's landlord correctly handle John's request under the Federal Fair Housing Act? And what if John wanted a cat or a ferret instead? So the answer is no. John's landlord did not handle this request correctly. The landlord cannot charge John a pet deposit for his animal because it is not a pet, but rather a service or companion animal required for disabilities. Further, the landlord cannot ask for proof that the animal is trained. Lastly, as service companion animals do not have to be just dogs. They could be other animals such as cats or ferrets. And then here's some resources. Here's that link, I believe, that we talked about where I showed you guys in a previous chapter. Let me just open it, make sure that that's the same one.
So in other words, you can charge them a fee if they had a dog, as long as it's not a service type dog.
For a pet.
For a pet. Now, and you can't ask them for a doctor's, that is a service dog. That is what their prescription was?
No. That's not what that said. Hold on. Let me go back here.
Mhm.
Let me see. Disabled, defined as fair housing. His doctor prescribes a dog. John asks his landlord if he could have the dog as a reasonable accommodation. His landlord says yes, but John, he'll have to pay a $250 pet deposit and must provide proof that the animal's trained. He didn't say anything about getting a prescription. I mean, the landlord can
Does that make it okay if he asked for prescription?
Yes.
Okay.
The landlord can ask for proof that it is a service animal by having a the prescription, and that needs to be renewed. If memory does serve me correctly, every 2 years. Okay. So I opened up that website link, and this is it. It's on the Humane Society's website where I got this, where they put together a nice little thing here pertaining to this security deposits on pets and what is considered a pet, and service animals. And it basically gives the breakdown. There's no official certification or training for service animals. Why? Because why can't the person with the disability train their own service animal? Well, first of all, most people probably can't, but what if they can? Now you're going to make them spend additional money. You see, these are some of the arguments sometimes. I found a bunch of great YouTube videos from people with disabilities who have requirements of service animals, where they give explanations of some of the issues that they come across from their point of view, and how people treat them and such. There's this one case of this one girl. She has a whole YouTube blog about this stuff because apparently she got a service animal. She loves her service animal. I'm not sure what her disability is for it though, but they can't ask. If you go into a store, they can't say, oh, you got to get that animal. No pets allowed in here. Say, this is a service animal. They can't be like, well, no. well, in this case, this lady, this girl, she actually filmed it. That she was in New York, and she went to she came to New York. She was visiting family, friend, whatever, and she took her service animal, went out to the corner store, whatever, and they're like, no, get the service animal out of here, or get the animal out of here. And she's like, well, he's not a pet, he's a service animal. And the guy was just rude. It was like, get that animal out of here. No animals allowed in the store. Health department, I get in trouble. And she's like, no, you don't understand. I need him for medical. This is a service animal. It's not a pet. Get out. Okay. So she leaves, and she came back with paperwork about the law. And she asked them, can I talk to your manager? She asked the manager, and she's explaining to him that your guy here, he was so rude. I tried to explain to him but my rights have been violated. You violated my civil rights here. I have civil rights to have a service animal, and he violated my rights here, said that I cannot have my service dog in here, and I need him for medical reasons. So I'm coming back here, and I'm showing you what the law is so that you don't do this to future people, okay? This is a right. I have a right to have that animal, and the federal law says so, and, they tried blowing her off. Oh, I'm sorry. Then the guy starts backpedaling. Oh, I never said that. You could come with your dog or whatever. And then they started changing their stories again, and she said that she kept having issues with these people at this store. These could be huge fines for business owners like this, though. Okay. Anyway, you can't violate their rights, but as long as you know that it is a service animal. All right. Anyway.
Quick question. So if John has been diagnosed, so basically if the landlord can try to be sneaky and say, okay, I'm going to up his security deposit at this point. If he was collecting only 1 month, he could up it to 1.5 by having to allow.
Well, the law allows you to collect up to 1.5 months security deposit,
Right. Yeah.
As long as it's not pet security.
Right. He could, instead of saying pet deposit, he could be collecting an additional security deposit.
Well, no, it's just security. Now, if he's charging everybody, let's say it's a multi-unit building and everybody else is being charged only 1 month, but I have a service animal, why are you charging me 1.5 months? Now, a case can be developed there by that you are discriminating and that it is a hidden pet security deposit, even though the law allows you 1.5 months security deposit to charge. How come how come I'm the only one that's being charged 1.5 months security and everybody else is only being charged 1 month? If that's a case, you could make a good argument as to, it seems like it is discrimination and they are charging you a pet security, okay? But short of that, landlord can charge whatever the hell they want. Up to 1.5 months security. All right?
Yep. Thank you.
Late payments for rent. All right, so they can be charged to tenants. You got to check what your local rent control ordinances are. Not all municipalities have rent control. Some tenants must be given a 5-day grace period free from any late fees or penalties. So those would be people relying on Social Security benefits, old age railroad retirement pensions, or any other quasi-governmental pension. They have to be given at least a 5-day grace period. These are the people that have to be given at least a 5-day grace period free from late fees. If rent is due on the 1st of the month and the tenant did not pay on the 1st of the month, you could charge them late fees. Well, check your local rent control ordinances though, because if you're in a town that has rent control, they may have a rule against that too. You got to obey whatever the local laws are in your town. Rent control laws are from municipality to municipality. Not all municipalities have them. So, but the tenants, this is a federal law, 5-day grace period, free from any late fees or penalties. Why do you suppose that is? Well, Because the government, what if they're late sending out their check for the Social Security or any of these government pensions? Well, if the government's late sending it out, they don't want the landlord penalizing the tenant for it. So they got to be given a 5-day grace period before they could start charging any late fees or penalties. Okay. Now, always check your local rent control laws before charging late fees or penalties. Okay, let's do some highlighting in the book. Highlight security deposits. Do you have anything highlighted in security deposits already or no? Did I tell you to highlight stuff?
No.
Okay. So in the second, on the second line at the end of the line, under security deposits, highlight residential landlords may charge no more than 1.5 months rental figure as security deposit. And well, actually, I got some stuff here that's not highlighted. Now, it says for commercial leases, there's no maximum security deposit amount by law. You could charge as much as you could get away with charging for commercial leases. But residential, this requirement for 1.5 months security deposit, wherever the hell that was. Okay, here. That's only pertaining to residential leases. There is no maximum for security deposits for commercial. Can I have that anywhere in this slide? Just one I had somewhere. Anyway, the tenant is entitled to be notified where the money is to be placed in the special interest-bearing account used only for security deposits. And so let's highlight the tenant is to be notified where the money is being placed, what bank, the bank account number for security deposits, and the tenant is to be entitled to all the interest on the anniversary of their lease. Now, I gave you that additional info that you don't need for exams, but if the landlord does not give them their credit for their interest earned on their security deposits, the tenant knows their rights. The court could award them double the entire security deposit. Okay, so in the next paragraph, we're going to highlight if the property is sold, the landlord turns over the money, the security deposit money, to the new owner and notifies the tenant. The landlord must return the security deposits minus itemized deductions for damages done to the tenant, done by the tenant within 30 days after the end of the lease. Okay. You don't need to highlight the following sentence that says that the penalty is double the security deposit for that violation. But it says the tenant is not entitled to apply the deposit to the last month's rent, nor can the landlord keep the deposit if the only damage to the apartment can be construed as normal wear and tear. Late payments, we're going to highlight the title late payments. And on the third line, we're going to highlight that next sentence there, the third sentence that says landlords may charge a penalty for late fee of rent payments except to senior citizens receiving Social Security, old age railroad retirement pensions, or any other governmental pension have to be given a grace period free of any late charges for up to 5 days or for 5 days. All right. I'm not going to get into anything additional right now. We're going to stop right here. This is, what slide is this? Slide 20. Let me make a note. What the hell did I do with my pen? Slide 20, chapter. All right. Save, close. Poll, afternoon poll, and then we'll continue this to